Okay. So we just started the recording. This will be an initial interview, Todd, and the thought was to start with you and Ellen, and then possibly to circle back with the two of you later for follow-up questions. So we interviewed Ellen earlier this week.
There we are.
Oh, great. That's easier if we could say, yeah. So we interviewed Ellen earlier this week, and we're obviously doing you today. And then we're going to today. I'm gonna try to schedule some additional interviews, and I'm probably gonna contact Jim to get his input. Like, for example, with the BAA members, I know they have a lawyer. I'm not sure exactly, if she's still representing them, if I should go through her to schedule the interviews.
We're not sure either, so.
Yeah, I figured that. So I'll have to get I was going to get his input. And then there's a few other people who, and I'll just bounce this off you too. Vicky Rose in your office.
Yes, I mean, she's out today and tomorrow, so if you contact her, she won't respond till Monday, but.
That's fine. All right. So she should be easy to, get in touch with and schedule. And by the way, you're more than welcome to, if you'd like to sit in and listen to her interview, you're welcome to. I could send you the link. You could participate from your office. You don't have to. There's no need for you to, but if you want to, you're welcome to.
Okay.
And then one person so with Ellen, we talked about, I asked her, I said, who do you think maybe some people to interview? Because I think they wanted us also to interview some property owners. She mentioned Bill Ketchner from Easy Pickens. We talked about like the Moose Club, and anyway, so as we're going through this process, if there's this interview, just think if there's anybody else who you think may be helpful for us to talk to, let us know as we're going through this. Okay.
Okay.
So and then timing wise, just to give you an update, I'd like to get this done as soon as possible. And I think it'd be helpful for you, quite frankly, if this gets done sooner than later, so that you could kind of move on with, your processes, including
Well, the board is coming up again, so I mean, it would be nice if it was done before the next board meets.
Yeah, we'd like to get it done before the end of February. So we're gonna now. So when you talk to Vicky, just let her know, like, we want to kind of put this into high gear now, and
Okay.
Matt and I want to really basically give this I don't want to say pretty much our immediate attention. We'd like to get it wrapped, if possible. We'd like to have a draft report, within 3-4 weeks. So we really want to get it moving.
Sounds good. It's been difficult to not say anything to anybody.
Yeah, I mean, I just, I think it would be helpful for you in particular to do your job if we could get this done and get beyond all this stuff. So anyways, with that being said, when were you appointed the assessor of Enfield?
June 1st, 2021.
Okay. And were you appointed by the director of finance?
I was hired. I mean, my initial meeting was with the director of finance and Steve Belinda, who's the director of HR. I mean, I got the letter from HR, so I mean, I believe it was director of finance, John Wilcox, that made the decision.
And how did you come to the town of Enfield? Was there? Did you see an opening? Did you apply for it, or were you recruited?
Yeah, there was an opening on our association's website. I applied, did the interviews.
Okay.
Went through the normal process.
Prior to Enfield, I know you were the assessor in Bloomfield, correct?
Correct.
How long were you the assessor in Bloomfield?
4 years.
And prior to Bloomfield, where did you work?
I was a staff appraiser in, was that the job title? In Wallingford for about 4 years.
And staff appraiser, so you're not the deputy, is that correct? In Wallingford?
Correct. Yeah, I was one step down, so third step from the assessor.
Sure. And did you do like property inspections?
Property inspections, commercial. I ran the revaluation that they had there.
Okay.
Basically, any of the normal assessor's duties.
Prior to work, okay, prior to working in Wallingford, where did you work?
I worked for Vision Government Solutions for 8 years.
And out of what office did you work?
At the time, it was out of Northborough, Mass. But you weren't really in an office. I mean, there was a lot of field work and stuff and everything. So I started off as data collecting back in 2004, I think. And moved my way up to staff appraiser there.
And so were you commuting to Massachusetts, or was it a lot of just work in Connecticut?
So during the collection, I was on the road a lot. From October, November to January, I was in the office a lot.
And prior to working for Vision, where did you work?
I've had my own landscape company since the early 90s.
Do you still have that company?
I do a couple side jobs, but I don't have any employees or anything like that.
So Todd, do you have a resume? Because that'd make my life a little easier. Did you have like a resume you submitted with your job with the application for Enfield?
I do.
Okay. Would you mind emailing that to Matt and I whenever you get a chance?
Yep.
All right. So tell me about your educational background. Did you graduate high school?
I did.
And where did you go to high school?
East Hampton High, Mass.
Okay. That's right over the Connecticut border, pretty much, right?
It's in the Hampton areas, you know, if you know where Smith College is, or
Yes, that's not too far over the border, right?
no, it's about 20 miles.
Yeah, it's a nice area. And then did you further your education after high school?
So I didn't attend the 4-year college. I did do some continuing education in the landscape design and architectural field. But that was continuing education, a few classes when you know, the job allowed over at UMass.
So what type of classes did you take in landscape and landscape architecture and
yeah, it was tree identification, plan identification, that type of stuff, you know, more to deal with the landscaping side of it.
okay. And did you further your education other than through those courses?
Well, on field, I guess. I mean, I was a certified turf specialist in Massachusetts and Connecticut. So I guess you know, taking the classes and stuff and everything, the state classes and tests for that type of work. So I could apply pesticides, you know, both in the lawn and trees for both Mass and Connecticut.
And so it'd be helpful, yeah, to know what certifications you have in that area as well. And then how did you get into the valuation business?
My old neighbor jokingly chided me into, oh, you got to come work for me. He was a VP over at Vision Government Solutions, and always just jokingly and stuff, and everything, barbecues or whatever, said, oh, you got to come work for me. You got to come work for me. Life circumstances happened at one point, stuff and everything. So in 2004, I took him up on the offer.
And that's how it began. Okay.
And that's where it all began.
And so, so you started in the data collection, on the data collection side of Vision. You worked there for 8 years, and you worked yourself up. You worked your way up to being a staff appraiser, correct?
Correct.
What certifications do you have as an appraiser?
As an appraiser, none. I have a state certification, CCMA 2, which is the state certification for assessors. So
Do you have a CCMA 1 as well?
well, the 2 oversees the 1.
Yeah, no, I know that, but do you have to get the 1 first to get the 2?
You do not.
All right, so you just went right.
I did have it, but I also, you know, I went for the 2 afterwards.
No, but that's what I'm asking you. So you got the 1 first.
You do not need to get the 1 first, though. I mean, you can.
I understand, but you got the 1 first, right?
I did.
Yeah. So I'm just trying to confirm what you have. So you have a CCMA 1 and 2.
Well, they don't recognize the 1 anymore. I mean, if you have the 2, you're just a CCMA.
Oh, is that okay? Okay, I didn't understand. Okay.
It's like a higher.
Okay, so you have the CCMA. So you have a CCMA 2. Did you take any coursework and appraisals Did you take any appraisal coursework over the years?
Taken numerous, and then that's going to be on my resume. Dozens of classes, seminars, workshops.
All right, so you don't have to tell, we don't have to waste the time in this if it's all on your resume.
I've done the PA 490, which I think is going to be relevant. I've done the state PA 490 workshops that they usually hold once a year, the forestries.
But you're not a certified appraiser in Connecticut, is that correct?
Correct.
Could you do that if you wanted? I mean, what would you have to do to be a certified appraiser?
You can. It's a totally separate type of classes and courses, just like I could be a real estate agent as well.
Mhm.
And, more classes and stuff. I mean, the issue that I have, and a lot of assessors have of having both, is that as an appraiser, any opinion you give of value can be used in a court of law as a fact. This is, a licensed appraiser's stated value, even if I just said, oh, I think your house is worth $150,000. So it lends another legal liability to an assessor if they have an appraiser's license.
All right, essentially, I don't agree with that. From somebody who tries cases, I don't agree with that. I think that if you're not a disclosed expert and they put you on the stand and asking how you value the property as part of the reval, I don't think the fact that you'd have a certification and an appraiser certification would allow that line of inquiry as some people have maybe suggested. I mean, just having tried cases, I don't think so. I wouldn't have that.
Right. It's just what I was told from actually my old boss, who was an appraiser and stuff. He says,
Nah, I wouldn't have that concern at all. I mean, I don't think it matters. Although I always tell appraisers, assessors I work with who I think are good, I go get, if the towns are paying for it, go get more training, go get more to add to your resume. Just don't leave me, but go get your MAI. I don't know. I always.
I am on my way. I'm a couple of classes short of getting my CAE, which is international, the IAAO classification of the MAI, basically.
So how does that work? What's it called?
CAE, Certified Appraisal Expert, I think, or don't quote me on that one.
And that's under the Appraisal Institute?
That's under the International Association of Assessors Officers, IAAO, not the Appraisal Institute. Appraisal Institute just has courses and stuff.
So that's a good. I'm surprised more people don't get that. Then that's a good certification to have. What?
A lot of work.
Yeah, it's a lot of work, but if I'm putting somebody on the stand, I like to have. It's nice that they have that.
The more letters after your name, the better.
Yeah, I just think it's especially if if your employer's paying for it, I think it's a good thing to get. I mean,
yeah, I agree.
And I think it's also good because there's a lack of assessors in Connecticut. I don't mean to get off topic, but like in Norwalk, I don't know how much longer I'm going to keep being the corp counsel, but it's like it's always my responsibility. It seems like if there's a problem with the assessor's office, everybody comes to me. So, I'm one of the things I've been saying is we got to get who after Bill Ford, and Bill to his credit likes to teach. I don't know if you know him. Wants to teach people and train people. So it's like, who's next? And let's keep getting them educated. And
yeah, it's been tough.
There's not enough assessors in the state. It's a huge problem, as you know, I would assume. So you're in the process of getting your CAE. If you could let us know, obviously, I'd like to put within our report, what your background. I'd like to put what your qualifications are, and I think it's helpful to put that you're in the process of obtaining that. And so if you could just, when you get a chance, just shoot Matt and I an email and let us know where you're at.
Yeah, I believe the reason I haven't had it so far is I believe 2 more classes I have to take, and a lot of times the classes are Virginia or Pennsylvania or Florida. I mean, they don't really hold them around here a lot, so it's been difficult to get those classes scheduled. So basically I have 2 more classes and then I have to sit for the exam.
Okay, so could you just send to us just a brief summary of what you're in the process of obtaining, and what it is, and what it means, and how far along you are. We'd like to reference that.
All right, and as far as the education or background goes too, I mean, I did work construction for a few years, so being in this line of business, looking at buildings and houses and stuff and everything. I do have a construction background as well.
That's where I'm going with this. I think you could understand, kind of figure out where I'm going with this is I want to understand, I've heard, you know what you're talking about, you know what you're doing, and it didn't just happen overnight. There's
Right.
things you're drawing from, and I want to know what those are.
So, I mean, to start from grade school, I guess.
I don't
My
go that far. I don't want to go that far back, but okay.
Well, neither do I.
No, it's
Well,
fine. Go.
my father grew up on a farm. He grew up on a 50-something acre farm or whatever. My grandfather had a huge farm. When I was growing up, my father had 3 acres of farmland, that we literally farmed on a yearly basis, whether it's vegetables or asparagus and stuff and everything. So, I mean, I have the farmers and the PA 490, obviously been doing a lot of this already. Is
it fair to say that? So is it fair to say that you actually grew up on a farm?
Yes.
And how long did your family have an active farm for?
Since I was probably 6 years old.
Until when?
Well, until I left the house at mid-20s or whatever.
Okay. And that was in Massachusetts, right?
That was in Massachusetts.
Was that farm exempt?
So they never applied for anything for that.
All right. But your
And I'm not
family,
sure.
but the
Go
bottom
ahead.
line is your family had a farm. Yeah, your family had a farm,
Right.
and you grew up on a farm. Okay. And you said your grandfather had a farm.
Yeah. I believe he had like 50 acres, something like that.
I didn't mean to interrupt you. You were saying that you don't think they applied for exemption?
Yeah, they never applied. I mean, it was I don't want to say a home farm. They actually did sell fruits and vegetables on, it was one of those farm stands on the side of the road.
Yeah.
3 acres of asparagus that, part of the kids' duties was one went out and helped pick it, and the other one stayed on the, in the house to sell it. And we would rotate all the time and stuff and everything. But I do have a farming background. So I'm very cognizant of, all that stuff. I'm not a soil scientist. I'm sure you've read some of their documents and stuff and everything, but very familiar with the farming side of it. And then I got into the landscaping side of it, and we did the whole 9 yards from mowing lawns, cleaning leaves, to installing outdoor lighting and ponds and brickwork and all that stuff and everything. So I mean, right now I've got almost 30 years experience working outdoors and landscapes and living things and that type of thing. So I just have a lot of life experience with that.
How long have you had your landscaping company for?
I want to say since I keep going back with this, probably 92.
And at some point, how many employees did you have? How big was the company when you were doing it full time?
Full time, we had over 20 employees.
Wow. And that was your company that you ran?
It was me, my brother, and father.
All right.
We
So
were all
family business.
Yeah.
So family business, and at some point you had 20 employees, a fairly substantial business, I assume.
Yeah, it was over 7 figures.
I mean dollars wise, but just, yeah, okay, that's helpful though. But bottom line is a substantial business, landscaping business that you had for many years. And when you got into this work with Vision, what happened to the company at that point?
So as with the many family businesses, there was disagreements. So the family business ended up splitting.
I could have assumed that.
I took part of the business. My brother took the other part. So I ran that with a smaller crew, just 5 guys and stuff and everything at that time. And then the life circumstances, getting into Vision, I ended up going through a divorce. So that's what kind of prompted me going through switching careers, basically. But I did I had a crew that ran the day-to-day things, and I did all the billing and, getting new customers type thing and stuff and everything. But what really got me out of the business was the employees. When the boss is away, the mice will play type thing.
Yeah, and it's gotten harder, obviously, with especially in the Northeast, quite frankly, to run businesses, small businesses, and everything that goes
on. So now I have
stuff.
3 customers that I do on my own on the weekend type thing, because I still like working outdoors. But, just a couple things on the side.
It's therapeutic, as I tell my wife.
It is.
So where do you live now?
Southampton, Mass.
Oh, so you still live there? Okay.
Yep.
Which actually isn't that far. It's probably 20 minutes from Enfield?
25 minutes, yeah, depending on traffic.
Is it closer to Enfield than Broomfield?
Well, yeah, Bloomfield's south of Enfield. Enfield's as close as I can get and stay in Connecticut.
That's what I thought. Yeah, Bloomfield's what, another 20 minutes?
Yeah, about that. Well, no, yeah, another 15, 20.
So you saved a little time on your commute going to Enfield.
Yep.
So when you were in Enfield, so first of all, when you were in Wallingford, how many were you involved with any reevaluations?
I was. I mean, I was appointed the lead person for the reval, and that was, I'll get the year wrong. It might have been 2009.
But you were in Wallingford for 4 years, correct?
Correct.
So did you work on one reval or two?
Just one.
Okay. And who was the revaluation company at that time?
Vision appraisal.
And then when you were in Bloomfield, did you have a revaluation while you were the assessor?
I did.
How many?
One.
And who was the revaluation company?
Vision appraisal.
And so and by the way, you from Wallingford, you went from a staff appraiser to the head honcho as the assessor in Bloomfield, correct?
Correct.
Is Bloomfield size-wise, how does it compare to Enfield?
It's a hair smaller. Well,
Okay.
I don't want to say a hair. It's about probably half the size. I mean, so Enfield has about 16,000 properties. Bloomfield has about 8,000. But the makeup of Bloomfield is a lot more complex. There's a lot of more commercial and industrial. There's a lot of engineering and aerospace type manufacturing there. So the Bloomfield's very complex on their commercial industrial side. Enfield's fairly simple with all the retail and shops and stuff. But Enfield's about twice the size of Bloomfield.
Both in parcels and in geography?
Yeah, about that. But it's not a lot bigger on the commercial side. I mean, we have about 2,200 commercial properties where Bloomfield had about 1,400.
How about with regard to population?
We're about 40,000. It's about half. I mean, about 40 and 20.
All right, so Bloomfield's 20 and Enfield's about 40.
Enfield's about 40, Bloomfield's about 20.
Yeah, so when you went from Bloomfield to Enfield, essentially it's a bigger community that you're handling. Okay.
And on the vision side, I mean, I've worked probably in 60 different towns over those 8 years, and probably been involved with 30, 40 different revaluations.
I want to get to that in a moment. I want to ask you, why did you go from Bloomfield to Enfield? Why'd you decide to apply in Enfield?
Well, I mean, there was some issues in Bloomfield with management. I don't know if you're familiar with Bloomfield, but they just lost their town manager again. He's retiring. This is going to be the 4th town manager. They've gone through a lot of upper echelon changes, from the tax assessor to the DPW. Just about every department has changed heads at least once, if not multiple times, except for the town clerk and the tax collector. So they have a lot of issues going on there. That was one of the reasons. That was the main reason I left. I probably wouldn't have been looking if it wasn't for that, because I was happy there. But then Enfield came up. It's half the distance. It was more money. So those factors involved. This had a pension or a defined pension plan where Bloomfield didn't. So it's just a triple win move.
Yeah, that makes sense. I mean, the finance, more money, shorter commute. Those are important factors as well. Yeah. So tell me about your work with Vision. So you did it for 8 years, from data collection to being an appraiser. Tell me about your work there.
So it started off with just doing data collection, which is just going out measuring houses. I think I did one town measuring houses, and then they saw the potential, I guess. So they moved me right into the commercial side. They put me in a town by myself doing the commercial. I did the commercial for a number of years. For a couple of years, moved me up to crew chief fairly quickly, and then fairly quickly up to staff appraiser. So I got involved in the actual setting of the values doing the tables, the cost models and stuff and everything for the revaluations. Was involved in the informal hearings pretty much from the start. So probably 7 years of doing informal hearings. Which if you're familiar with revaluations, you know, the companies always do an informal hearing before the BAA.
Yes, sir. Yes.
So then, you know, at the end and stuff and everything, I mean, I was helping, you know, actually set the commercial values. It was more on the commercial side than the residential. But I was setting all the market rents and the vacancies and, you know, helping reconcile all the values for the commercial properties. And I think the last, it's not going to be an accurate number, but I've probably worked in about 60 different towns in Connecticut. Well, I don't want to say Connecticut, between Connecticut, Mass, New Hampshire, and New York. I've been involved in 60 different communities.
And when you say involved in 60 different communities, are you referring to performing work associated with revaluations in approximately 60 municipalities throughout those states that you just mentioned?
Yes.
With regard to your involvement in as an assessor, whether it be as an assessor or in your role in Wallingford as a staff appraiser, what was your experience in handling quadrennial applications?
So in Wallingford, I mean, on the vision side, we didn't do have any dealings with that side of the assessor's office. Started that in Wallingford, that I would help review any of the quadrennials that came in to determine if they were actually had the right paperwork and documents that they needed, and if they were in fact exempt or not.
Tell me about your experience with PA 490 farmland, open space, and forest land exemptions.
Well, besides all the pre-qualifications, I guess, of being the farmer and growing up, taking the classes at UMass, I've gone to the, you know, Connecticut.
Excuse me, if I can interrupt you for 1 second, just so I don't forget. The classes with UMass, did you say that's on your resume or not?
Well, it's the classes themselves aren't that I attended a continuing ed at UMass is.
All right, but all right. So to the extent that you have classes that you took with regard to your landscaping work and other classes you took there, it'd be helpful if you could give Matt and I a summary of that. I didn't mean to interrupt you. I apologize for interrupting you, but I didn't want to forget. I want to make sure that I got that. Okay, let me
I'll
finish.
see if I can dig that one up. That's been a long time. The actual names of the classes.
Well, that's yeah. That's why I didn't want to forget. I want to make sure I was specific about that. Okay, so I interrupted you. If you want to, I was asking you what was your experience with PA 490 farmland, open space, and forest land exemptions.
So the PA 490, like I said, I took the state workshops. I've taken them twice so far that they hold. It's usually a 1-day class on, you know, what PA 490 is and how it's supposed to be administered and the reasons for it. I am on the CAAO committee for the PA 490. So right now we are involved in helping set the new standards for PA 490. You know, the state is coming to our association asking for recommendations or what we would like to see happen with the laws. There's been some changes going on with the shell fishing side of it and stuff and everything. So I've been involved on the PA 490 probably for 4 years now. 3-4 years. It's been a while. I mean, that's on my resume as well. That I'm on that committee. So I'm well versed as far as what's been going on. I mean, I hear a lot of different things from different towns because, you know, the town will come to our committee and saying, hey, I have this issue going on. You know, what do you guys recommend? And also on the, there was something else I wanted to say on the quadrennials. I forgot what it was.
Well, so I was specifically asking about PA 490 farmland, open space, and forest land exemptions. And by the way, if you remember what you wanted to tell me on the quadrennials, that'd be helpful. And you could tell me either during this interview or if you remember later, you know,
Sure.
just call me. So on the state committee, is it fair to say that there's is it accurate to say there's a subcommittee of the
CAA.
Yeah, for the CAAO, there's a subcommittee of assessors that are assigned or appointed, I should say appointed, and to deal with, is it just is it all PA 490 or just farmland?
PA 490 is farmland. Farmland is a subcategory of PA 490.
I understand. What I'm saying is the subcommittee PA 490, meaning that you guys are handling farmland, open space, and forest land, or is it just the farmland committee?
The former. It's handling everything under PA 490.
Okay, handling everything, and so and your resume will indicate how many years you've been on that, correct?
Yes.
And in doing that work, do you work directly with the OPM, the state of Connecticut, to discuss potential legislation with regard to PA 490?
The committee chair deals. So me personally, I don't deal with them, but the committee chair does, and then comes back to the committee and discusses what's going on with OPM.
Well, I've been invited to some of the meetings with OPM. Have you attended any? Have you been asked to attend any of the meetings as a committee member?
No.
But is it fair to say that your committee deals directly with OPM, and that OPM? So let me ask this: does your committee deal directly with OPM? We do. Does OPM take input from your committee with regard to potential legislation pertaining to PA 490? It does. Let's talk about soil classifications. This is a really hot, sexy topic to talk about. So tell me what you know about tillable land, A, B, C, etc. So I will state right from the beginning, I'm not a soil scientist. Okay. But I understand. Neither am I. Yeah, well, it's in the minute, so. I know. Soil classifications, the way I approached it was PA 490. Let's start. So there's three things basically that have always been taboo for assessors: veterans, elderlies, and farmers. You never touch those, and this is just a backdrop of what it used to be like. Things have been changing a lot over the years. There's a lot more oversight, a lot more eyes on what people do in government or anywhere. So things have been looked at more closely probably over the last decade. When I get into a town, this is my first town, I was hired in this town to clean things up. They knew there was a lot of things that were done by handshake or just, there was a lot of issues that the town had that they wanted cleaned up. And that was on the premise, that was one of the premises of why I was hired to clean things up. Well, I'm going to ask you a follow-up question on that. So you could keep answering. That's helpful that you said that. We'll get to that. But why don't you keep answering this question, then I want to circle back to that. So because of the revaluation, that's always a good time to look at everything as far as property goes, whether it's quadrennials, farmland, exemptions, anything like that. So one of my first things here was to look at all their farmland, and Enfield has a lot of it. Their records were in disarray. They were all over the place in different folders. It literally took me months just to clean up the folders, to get all the paperwork, all the documents that belong to one property in one file folder to review. Once I had all that done, I visited each property, took pictures, went and actually, looked at every single one. Some of the farmers took the ride along, or I rode along with them so they could show me their multiple properties. I reviewed all their past documents, everything that we had in the folder, might have been back 40s or 50s, going forward. Enfield had the policy of sending out a abbreviated form every year to a farmer, and it was basically, I don't think it was a good idea the way it was set up, but it was basically just check off if you're still farming type. Todd, let me just, so I don't want to lose sight of this, and I want to have you keep answering the question with regard to the form. Just if you could just make a note as we're going through this, there's certain things I'm going to ask for you to provide to us. Make a note if you can. Provide to us the old form that the town used to require, and then the form the new form that you required that you, and then if you could just, when you email it to us, just tell us, here's what they used to use, and then here's what now I use, and here's why. That would be helpful to us. Okay.
Okay. So just to clarify on that, I don't require any new forms. The town just had a form that they had sent out. But I reviewed every single document and for every single property, and things that I was looking for is if there was any sales or transfers, forestry updates, applications, and what somebody would have to do in order to comply with the state statutes to stay in farm. And as I went through the properties, I would send out a letter to each person saying, hey, we're reviewing all this. Looks like there was a sale, we need an updated farm application. We need an updated forester's report. There was a sale or whatever, please get me this information. Some people complied. Some people reached out and actually got us the documents. They went out. The forestry division was very helpful. They expedited a lot of their inspections to get us all those reports. Other ones ignored it, or I don't know. Other ones didn't respond. Some of them had a little bit more of a lead time than others, just because I started, I want to say in September, October, sending stuff out. But as I reviewed them, so some of them weren't until December by the time I got to review a property. So they might have had, they still had a couple months to respond. I did expand the time frame that they could respond because it was supposed to be by the end of December. But I gave everybody until the time I signed the grand list, which was the end of February, to get me the documents. Even though I could have cut it off at the end of December and saying, sorry, you're too late getting me this stuff. The soil classifications where this all started from, as I was reviewing the farmers, they would submit, there was multiple applications, and one year it would have tillable B, next year it would have tillable C, one year it would have, it would flip flop back and forth. So what I was trying to do on the soil classifications is I was going back to what they originally applied to. Because I don't think the soil changes over the years usually. I mean, it takes a long time to change nutrients and all that type of stuff and everything. So I was actually going back. So if they originally applied for tillable B, their new one was on tillable C, I moved it back to tillable B. So that was the reason for some of the moves, the soil classifications from the 4 different tillables. Does all that make sense?
Yes. Are you aware that there's a difference in the value for different classifications of soil, depending on whether the community is within the Connecticut River Valley is considered to be a Connecticut River Valley municipality?
Yes, there's 2 separate tables.
And why is that?
Well, my opinion, I mean, I don't know for sure, but I mean, my opinion would be that the soil around the river valley is more nutrient rich because of all the flooding and stuff and everything. I mean, going back to my dad's farm, we had a river behind the house that always would flood the fields. That's why it was such rich soil.
So is it fair to say it's more valuable?
As more valuable as has more potential for farming.
And so with regard to the Connecticut River Valley municipalities, is the table, the values higher or lower for that table?
Higher.
What's your experience with valuing commercial properties, commercial and industrial properties?
Well, I think that's pretty much been stated. If you look through right from the beginning of vision appraisal, I started in my second town being the sole person, measuring and collecting the data for the commercial properties, moving up the field and actually setting the market rents, the valuations, expenses, that type of thing and stuff and everything for the commercial properties. And then obviously moving into the assessor side of it, you're responsible for all the values on the commercial side. The CCMA 2, the difference between the 1 and the 2 is primarily the commercial side. You have to take the income and expense classes. You'll see in my resume, I've taken multiple commercial workshops or classes. The IAAO 102 class is strictly on the commercial side on the income and expense. So, probably at least a dozen years or better, I've been directly dealing with value in commercial properties.
What is your experience in valuing residential properties?
Same, pretty much the same thing. I mean, I have multiple classes and workshops and stuff running on the residential side, on cost modeling, on the revaluation side. The big difference between an appraiser and an assessor, the classifications, is that appraiser is doing a fee appraisal. They're looking at one property and going out and comparing it to a certain select number of properties, whereas in mass appraisal, you are basically setting the market rents based on all the income and expense for the whole town. And then for the ones that didn't sell, you're applying all those markets to the rest of the town. So that's true on the residential side too. You're taking the 2,000 sales that happen throughout the town and then doing an analysis and cost models on that and applying it to the 14,000 other properties that didn't sell. So you're looking at all the cost rates, the building rates, depreciation schedules for both residential and commercial.
Tell me about your, could you please tell me about your experience with personal property value?
So that started off in Wallingford. Again, Vision Appraisal only does the revaluation side, real estate, nothing to do with personal property. So I started off handling personal property in Wallingford in 2012. So I've got about 9-10 years, well, 2009, so 13 years, 14 years experience doing that. Going out and visiting properties, doing in-house audits. We'll take some of the smaller properties and actually do an in-house audit where we'll review their tax documents. We'll go out and look at their properties, take pictures of the equipment and stuff and everything, come up with a value. Dealing with the personal property declarations every single year. I review all the manufacturing lists every single year, the M65s, to make sure that they're in compliance with the state statute. My policy has always been, from when I was the head honcho, as you put it, in Bloomfield going forward, is that we do a certain number of audits every year. And the audits are always handled an independent company. But obviously I'm very well involved in reviewing everything that they're doing. We go back and forth on what they have. And again, other classes and workshops and stuff and everything, dealing with the personal property.
As far as the independent company, is it Chuck Feldman or somebody different?
So in Wallingford, it was Chuck Feldman. In Bloomfield and here in Enfield, we're using Bearing Appraisal.
Okay. Over the years, I've only dealt with that I can remember is with Chuck Feldman. I was just curious who else was out there.
Yeah, I prefer, Chuck's a great guy and stuff, but I prefer Bearing Appraisal's approach.
Okay. Yeah, there's not a lot of companies that specialize in personal property value, as far as I know, correct?
There's not.
Tell me about as green technology increases, there's more and more equipment, whether it be solar panels or other green energy equipment that assessors have to deal with. Tell me about your experience with valuing and assessing equipment and basically personal property that has to do with clean energy, including solar panels.
So there wasn't much in Wallingford. Started pretty much in Bloomfield. Residential solar's pretty much never been picked up. Although it might be picked up on a field card, it was never valued. There was never a value placed on it residentially. It's been a hot topic probably in the last 6, 7, 8 years. I was one of the, I think it was 13 or 15. I'll get that number wrong. There was a number of communities that were involved in a tax appeal with the solar companies. My belief was, and these other communities that were involved believe, that the solar company that was putting the equipment on the residential houses was a business. It was basically a small utility company. And they would have to supply a personal property declaration. So we started taxing the company for their equipment on the residential houses. We didn't tax the house owner, the homeowner, but the company that owned the business, all their personal, basically the equipment they were making money on. That did go to court. It was settled. And then the legislation, basically, the court didn't really want to deal with it. They said this is really a legislation thing. They kind of wanted to let the state legislation deal with it. And they eventually did, and they kind of changed the law, tweaked it a little bit and stuff and everything. So now that they are exempt, but they had to change the law to make that, effective.
And you're referring to Connecticut General Statute 1281 subsection 57, is that correct?
It is.
And the amendment to that subsection, I guess, clarified the exemption provided for rooftop solar on residential properties. Is that correct?
Correct. Right. So it was always exempt. Well, it was always exempt if it was on a commercial building or a farm, and it was being used solely for that property, and it didn't exceed, the wattage or whatever.
The load. I think you're referring to the load, correct?
The load, yeah. Thank you. For that property. So, that those were always exempt. They did have to file the forms and stuff and everything. Now, if a company came in and just did a solar farm, that did become taxable because it wasn't being used for that property. It was going out into the grid. So that land became taxable, and also the personal property became taxable. That was true even like in Bloomfield. There was a company that came in and leased land from the town Board of Ed, well, town property. That land now became taxable as well as the personal property. And it was interesting that, as is usual, the assessor was never brought into the conversation until the 9th hour. If the contract,
that's a mistake, by the way, of communities, and it's also a mistake of everybody involved. That the assessor's office should be, because I've gotten involved where I've said to towns, everybody should, town deal with the Connecticut Green Bank, and one silo in the town dealing with this and making references to the fact that something is going to be exempt, and then no one's telling the assessor.
right?
And then that's, I agree with you on that.
That was the problem in Bloomfield, is that in the lease agreement, it specifically said that the lessee was responsible for the taxes. I went to the town and said, just change the lease to say that the town is responsible for the taxes and it'll be exempt, but they didn't do that. So now that land became taxable to the lessee. They had to pay the taxes on the land, which they didn't plan on. Planned on the personal property side, but not the real estate side. So I've had quite a bit of dealing with the solar on that side of it. I mean, there is some here. I know there's and I don't know if you want to get into this part of it and stuff, but there was a tax agreement, not an assessment agreement, with one of the properties here that the BAA heard, and the BAA ended up exempting the property, even though it was an agreement for the tax. It was a tax agreement for
the
property.
Yeah, let's. I think that's on my. That was which one? That was.
It was a Jarmuck property.
Yeah, we'll get to that. I think, Matt, is that on our outline here? Is that on there?
Yes, it
All
should
right,
be.
we'll get to it because I've got the exhibits on it.
Okay. So I have had a lot of dealings with that side of it. And then there's the whole, and there was just a court case on the cogeneration. There was just a court case on the cogen, because cogen was never, it was basically excluded from being exempt on a property. And there was actually just a court case in Groton that kind of reversed that a little bit, saying that cogen, should be exempt.
Say that again. There's a case in Groton that said what?
That the cogeneration it actually is going to be exempt for that property.
Okay. And that was out of the New Britain Tax Court?
I believe so.
Okay. It's helpful to know. I mean, by the way, my 2 cents on, I'll just give you my 2 cents on the solar panel stuff and on these things. I think everybody a lot of times people overthink things. And by the way, for whatever it's worth on that stuff, what I did was I looked at, who was involved with the legislation. I saw it was Senator Bob Duff. He was the head of the committee at the time. And I called him and I just tried to figure out, and I know Bob, what happened? well, what was your understanding? And I could tell you his understanding. And then I had him do a letter, and I know that was ignored by a lot of folks. A lot of town attorneys said, that's right, I don't want to see it. And just on the most simplest of terms, I mean, the most simplest, I try to, I keep things simple. It's easy I'm simple-minded. Everybody on the committee, at least according to him, and he could speak for himself, was aware of the fact that rooftop solar on residential should be exempt. The issue of then when you have a company leasing it, does that now take away the exemption? I think the one of the things that assessors maybe didn't realize is this stuff doesn't really work without, from a financing standpoint. People aren't going to put rooftop solar if they have to spend the money to buy and install the equipment, and it really only works. There's a few exceptions, but for the most part, it really only works with a leasing model. And so the state legislature understood that, and the Connecticut Green Bank understood that, and the Connecticut Green Bank was involved with the legislation and legislature. So for whatever it's worth, I mean, I think that sometimes we overthink things, and I think that we have to think about things practically, and forget what a statute says, just practically. How does it work?
You can't forget what a statute says.
Well, before you analyze the language in the statute, let's just think about something practically. Obviously, as a lawyer,
I agree with you. I just don't know if the problem with the legislators is they complicate things or don't simplify things in the statute itself.
That's a frustration I have, by the way, and you know what? Shame on me, because there's more I could do to change legislation. I'm actually dealing with the Rules Committee next. So I've been appointed by the rules by Justice McDonald, who's a chief Supreme of our Supreme Court. The Rules Committee. There's a committee of 6 of us that are going to be looking at standard discovery in Connecticut. Not to get off topic, but I felt strongly for years we should have standard discovery, and I fight really hard, and Matt knows this because people think I'm maybe difficult, but I don't think I am. We're entitled to certain information and documents, and I find that there's tax representatives in particular that hide it. The bigger the corporation, I find not always, but sometimes these big REITs conveniently hide stuff or conveniently don't provide us with certain things, and I think it's a big problem, and I think that the courts have allowed it to happen with no consequences. And I think there's
longer there.
Well, and I think there's lawyers who, I mean, in fairness to Judge Cordani, he did a really good job of cleaning up the docket. The docket was taking forever, and to his credit, I don't agree with every decision. There's decisions he made on my cases, some of which I didn't agree with. He was a smart guy. He got it. He wasn't perfect, but I have to say,
his predecessor though.
Oh, Levine. Well, Levine, to his credit, every time I needed discovery, he hammered people. I mean, he knew I was fair, and he was, he would say, "Do you want me to rule on it?" And every single time he ruled, he always ruled in my favor, with very few exceptions. To be honest with you, I would say whenever I fight on discovery, 90% of the time I win on my overturning people's objections. Very rarely do I lose. I mean, and I've had some big cases. The mall in Norwalk was like a $450 million value case, and they were pushing back with objections, and we fought hard and won on every single one. So yeah, I just feel like, so anyway, so I'm on this committee with the state, with the Rules Committee, and so you have 3 people on the plaintiff side. It's Greg Servadidio, Amy Bloom, and Scott Schwescher.
I know 2 of them. I didn't know the first 2 names.
Scott Schwescher, so they're going to obviously be pushing to have less discovery, and then on the municipal side, I've been appointed out by there's 3 designees by CAMA and the Connecticut Municipal Association of Lawyers, and that's me, Owen Weaver, and Barbara Coughlin, who's a in-house at Barbara's in-house for Stanford, and Owen is an attorney at a firm in Orange. He does Fairfield and Greenwich. So it should be in Orange. So it should be interesting. We're going to be, I think our first meeting is early next week. We already met with the rules committee, but we're going to try to be coming up with different form discovery for cases. And so anyways, it'll be interesting. My other idea is I'd like to amend the statute. And I've been saying this for years. So eventually I got to get your association on board with this. And I think I will be able to amend 117A to provide that to take the ability to raise the assessment away from the BAA in 12.111. Actually, to change 12.111 and 12.117A, take away that right from the BAA, because it makes no sense for me why the BAA could increase, and instead give that right to the court after a trial. So if you go through a whole trial, and right now most courts, most judges believe they cannot raise the value. They can only, so for example, if let's say we have a case where, like in my mall case, our appraisal was 30 million above the town, above the city. So, but if we went to trial on that, they had no risk of, so I think like the assessor, let's say, was at 300 million for the mall proper. He was at 300 million. The plaintiff was at 225, and our appraisal came in at 330. So if we went to trial and won, the most we could do is get to 300, stay at our 300. But why shouldn't there be a risk for the plaintiff to go to 330, that it could go to the 330?
I'd agree with that.
And I think if we do that, what's going to happen is these tax reps, when they send out these mass letters, these, the mass mailings, and they say, you can't, we'll take your case, it can only go up, it can only go down, it can't go up. Now they have to put people on notice that, listen, by the way, it could go up. And that's a big change. And so when they file these lawsuits that don't have merit, and I know there's a requirement of the appraisal now, they've got to think twice about filing them, because now the town counterclaims for a higher value, and now they can't get out of the case unless they can't just withdraw. Anyway, so
you should push to have the appraisal part of it, the statute that just got passed, from $1 million to 500,000. Though $1 million is too high
for the appraisal.
Yeah, probably has to be assessed at $1 million before they're required to have an appraisal.
Yeah, I agree with that. I think it should be even higher, to be frank with you.
Think
I mean,
so?
Yeah, I only need it on the bigger ones. I mean, on the smaller ones, I don't need their appraisal. First of all, most people, if they're filing on a smaller property, they're giving you their appraisal, the BAA, or they're giving it to you up front. You don't need, it doesn't matter. I mean, they're going to give it to you anyways, usually. I think
I rarely get one for a smaller property.
I get them usually on the smaller. I'll say, listen, tell me, we don't, to be honest with you, I don't, maybe it's because we're downstate a little bit. We don't deal with that many small ones.
Well, Fairfield County is a little different than Hartford County.
Yeah, we just don't even deal with it. To be frank with you, we have very few appeals that are, very few appeals that are not way over the threshold. So we almost never have them.
I've done a lot of work down there in New Haven, West Haven, Westport.
Well, New Haven and West Haven are a little different. They're lower. There's no doubt about it. But they have a good assessor in West Haven. She's really good.
Anne Marie, I like Anne Marie.
Yeah, we've tried to recruit her a couple places in Fairfield County. She doesn't want to leave West Haven. They're very lucky to have her. She's excellent. So anyways, not to get off topic, but there's a lot of things we need to do to improve the process in Connecticut, in my opinion. So with regard to and by the way, with the personal property audits, I think they're really important. And I think a lot of communities leave a lot of money on the table and because they're sloppy. The assessor's offices are sloppy, and I don't want to say sloppy. I hate to say the word sloppy and lazy, but
constrained.
They're not doing their job, quite frankly. And so let's talk about audits. Were there any audits being performed prior to you beginning the assessor in Enfield?
Yes.
How often?
Every year. There was a line item in the budget for it. Yeah.
So they were doing them. Okay. So you've just consistent. So you maintain the same number of audits approximately?
I did. Well, actually, I increased the budget for it.
Okay. So you're doing more audits of personal property?
Yes. The budget was 10,000. I think I increased it to 15.
Okay. And with regard to new construction, have has there been a difference in the way that you're handling new construction permits and valuing it versus from when you know, prior to you being there?
I don't believe so. I mean, I don't have direct knowledge on how they were handling it, but according to my assistant, nothing's really changed as far as prorations or anything like that. New
Okay,
construction.
so that's good. So they're keeping up with it. Some offices don't. That's why I asked the question.
Biggest thing that they weren't doing the situs rule on new construction.
They weren't doing the situs rule on what?
On the new construction, on the construction company.
What do you mean by that?
So the situs rule is that the town that the equipment is in for the 3 months prior to October 1st can claim that equipment. So if you're building an Amazon warehouse and you have all the bulldozers, excavators, construction equipment on that property for that year, or there's just certain language in the situs of the 3 months prior, that town can claim that, even though they're working here in Enfield, but their office complex is in New Haven.
Yeah, no, I understand the situs rule. The way you said it about, it made it sound like you're talking about real estate. That's what I was like, personal, like real property. That's why I got confused.
Oh,
So with regard to construction equipment, is it fair to say that prior to you being there, there was no attempt to apply the situs rule in order to assess personal property that qualified for assessment for a given grand list year? Okay.
I believe that's correct.
As a result of you applying that, do you know approximately how much you've added in value to the grand list on it?
Well, the first year might have been $1 million. This year I'm running at 50% staff, so I just haven't had the time to actually get out there to do it. I mean, that's one of the things. That's the item on the poll that's a little up higher. If you have the time to get out there, because you have to literally make visits, continual visits each month to make sure that all the same equipment is there, trying to get serial numbers and all that stuff. So this year we haven't had the staff to do it.
So let me ask you this. For last year, why don't you, your first year basically coming in, or first 2 years, could you send us a follow-up email and let us know by applying the situs rule how much you've increased the grand list for each of those 2 years?
Yeah, I'll see if I can see what I can dig up.
Even if you give me an approximate number.
Yep.
So you said earlier that one of the reasons you were hired was to clean things up. Tell me more about that.
I mean, they didn't really get into specifics. They knew things were lackadaisical. I don't want to disparage anybody, but there wasn't a lot of structure or strong-willed people in the office, at least on the upper end, to handle certain things that might come across the desk. A lot of things were let go because somebody didn't want to argue with somebody, a taxpayer or whatever. Didn't really like confrontation. So there was a lot of things that should have been done, but weren't. I mean, one example was there was a tax sale that my predecessor used to handle all the tax sales. She would actually do the soup to nuts, sending out the letters and the research and finding out all the liens and all that stuff and everything. And an attorney came up for one of the properties and says, "Hey, this wasn't handled right. Take it off." And she acquiesced and took it off. And I actually talked to the person now handling our tax sales, Adam Cohen, who's a specialist in that side of the field. And things were done properly. She did not have to take that off, but just because she didn't want to confront somebody, she just let it go by the wayside.
I'm confused a little. Usually the collector runs the tax sales. Do you handle the collector's office as well?
I do. Yeah, this is a dual role. Assessor and collector.
So you're in charge of the collector's office, the collection. So are you technically the tax collector as well?
I am.
And what certifications do you have as tax collector?
So in Connecticut, you do not have to be certified. The town wants us to be certified. So there's 4 classes that have to be taken and then a state test. I have the 4 classes. I've passed the 4 classes so far. So I just have to wait until June next year to take the test. And then there's a 3-year requirement that you have to be in an assessor, in a collector's office before you will get certified. So even if, and when I pass the test in June, I won't be certified until I have my 3-year requirement.
Could you make a note, send us a separate email and tell us what coursework you took to obtain your certification as a tax, what is the certification that you're endeavoring to obtain? And what have you done so far, and what do you have to do, including the waiting period, in order to obtain that?
Okay.
So aside from your example with the tax sale, what other examples do you have of things that were
Well, okay, so
differently?
one of the ones on the PA 490 that a gentleman wanted to do Christmas trees. So the assessor went over there to inspect the property, and he had a few Christmas trees in his garage, but nothing was planted. So she said, all right, we'll give it to you. He never ever planted any Christmas trees, but now he was granted PA 490 for his acreage in the back of his property.
And what property is that?
That was on George Washington Road. It was Scott Delorge. I have to look up the actual street number or whatever.
And when you came in, became the assessor and reviewed that, did you review that property?
I did. I talked to the gentleman on his property probably for about an hour.
And what happened?
Well, I ended up removing the exemption. And he agreed. He said, well, I couldn't do anything. It was too wet back there. I can't grow anything. It's just too wet to do what I wanted. So.
Can you please send us, make a note, please? Could you please send us a separate email and let us know what happened there? So give us copies of the record showing that it was previously exempt, and then provide us with and any notes that you have that were in the file about the status of that property, and then what you did, and any records confirming what you did, showing how this is a situation where, again, your predecessor handled it differently than you did, and here was the result. Okay.
I won't. I mean, we talked for like an hour. He was a landscaper, so.
Okay. So if you could provide all that to us in a separate email, it's good to have separate emails. So otherwise, it gets a little confusing.
Sure.
So what other you've given a couple examples of specific matters. In general, we talked about, what differences were there in your approach from your predecessor. For example, we talked about new construction and valuing it pursuant to 1253A, and it sounds like you're doing it consistent with the way your predecessor did for those interim valuations for new construction. It sounds like for personal property, your predecessor was doing audits. You may be doing a little bit more, but that there were audits already being done in the office. One change, it sounds like, is that your predecessor was not applying the situs rule, and you were. In kind of the broader sense of things that your assessor didn't do, your prior assessor didn't do, that you've decided to do. What other things were there?
Well, on the personal property side as well, I actually review all the M65 applications and all the equipment. That was never done in the past. Whatever they supplied on their M65 was just passed through for the most part.
As a result of that, what happened?
Well, just their equipment from their side, their equipment was just exempt. So the town was losing out on. I don't want to say the town was losing out on any money, because the town gets the amount of money that they need, but the other taxpayers were paying more than they should have been, because there was more of an exemption granted to certain companies.
So for example, as a result of you reviewing those M65 applications, did the town's assessments of the personal property increase in many instances?
The taxable assessment increased, yes.
And so how did your review enable the town to increase the assessment?
Just by reviewing, just by reviewing their M65 application, they're required to actually fill out all the equipment that they're qualifying and that they're asking to be qualified as exempt. And I would review each one. If there was a forklift on there that it isn't part of a manufacturing process, it would be removed. Shelving, that type of thing. I was removing a lot of those pieces of equipment, moving them from the exempt side over to the taxable side.
Could you provide me with an example, for example, of 1 year, 1 grand list year in which you reviewed these applications and what the difference was in increases in assessment? And then were any of those appealed? Yeah, what was the result?
That's going to be a difficult part because I was hired in June of 20 or 21.
Uh-huh.
Just getting my feet wet. I didn't do a lot the first year as far as changing any of the policies.
How
Second
about
year
this
was
second?
the second year was a reval year, and well, this is personal property side, so I'm like,
Shouldn't matter.
right. I was just
Shouldn't
going
matter.
in my head. Reval side, it'd be hard to pull stuff apart because
No, I
reval.
understand. I understand that. I'm talking about on this.
Personal property side, yeah, we can probably look at that.
You don't have to give me multiple. Just give me 1 grand list year as an example. So, for example, give it to me for your last full grand list year was not. It was. You were here. You're up and running. You did it.
I only have one that I was actually a full-time assessor under my
Okay,
belt so far.
All right. So give me that one and just tell me what the result was. What you did and what the result was. And then did any of those people appeal or did they all accept it?
We had maybe half a dozen personal property appeals, and it wasn't on that side of it. One guy did appeal his M65. Well, he appealed his M65 exemption, but he lost it because he didn't submit the form.
I guess my point is this.
No,
Of all the ones that you said, okay, there's issues here. You found the issues. As a result, the assessments increased.
Mhm.
And my guess is, and I'm just guessing, but my guess is that companies are like, okay, fine, he's right.
Yeah, we didn't get really any appeals on it.
So what I want you to do is to confirm for me what you did and confirm for me that nobody appealed and that they accepted it. So
other things would be the quadrennials. I mean, there was exemptions granted that never should have been. They didn't qualify. Private clubs that had an exemption for a decade. Those were removed. Although I removed them, they were put back on. But
some of them were put back. Some of them had appeals sustained by the BAA, but not all. But not everybody appealed, right?
Right.
Okay. Any other changes in policy that you made from your predecessor?
That would increase value. Let me think on that one. As far as
okay,
I made a lot of.
You can follow up later. Make a note. You said that that one of the reasons you were hired was to clean things up. During your interview process, did anybody on the town side tell you that there were concerns about the way in which the office was being administrated, and that they would hope to have improvements in the administration of the office with the new assessor?
It was implied that the office that my predecessor was soft, and that they needed somebody who's more strong-willed to be in the office.
And who was involved in those interviews?
Steve Belinda, the HR director, and the finance director.
And who's the finance director?
John Wilcox. So on that note, not to disparage myself, but I believe I was the best candidate. But from my understanding, there was only 2 candidates for the job. As you mentioned earlier, there's a lack of assessors in the state. The only other person that applied was my assistant, who they knew, in their opinion, wasn't a good fit either, because she's basically the same as my predecessor. She's kind of too soft. Just let things go.
Okay. Do you want to take a? Can we take? When do you want to take a 5-minute? Can we take a 5-minute break here?
Yeah, we can. But one thing before we go, just
why don't you tell me which? Yeah,
on
sure.
the changes I made on the motor vehicle side. I implemented using a software that was developed by the assessors, the Vindicode, to help identify actual prices of the larger motor vehicles on the list. Before, everything was valued just as a cab and chassis. So with this program, it increased the values. Was able to identify or help identify what was on the back of the trucks to get an accurate value on the trucks. So that actually increased the motor vehicle grand list assessment value.
Todd, could you please make a note? Could you please send us a separate email on that? Give us a description of the system and let us know for, $1 grand this year, what happened as a result of the change.
I will.
So what's your schedule like today? I'm just, trying to figure, want to be cognizant of your schedule.
I have a previous appointment. I have to leave this office probably about 3:15 by 3:20.
All right, so you got to leave by 3:15, right?
Right.
Okay, so we got to end by then. And how about lunch?
I usually eat at my desk if I eat. So
Okay, yeah, I'm same way a lot of times. Time, what time do you want to take a break for lunch?
I don't
Doesn't
need
matter.
to. That's up to you.
Okay. Okay. All right. So we got till 3:15. Do you mind if we just take a 5-minute break?
Sure.
We'll jump back on, or let's take a 10-minute break. We'll jump back on at 11:40. Is that okay?
Sounds good.
All right. Thank you.
All right.
I'm gonna leave everything on.
Yeah. know if you guys are there or not.
Hey, Todd, you there?
I am.
Hey, Todd, sorry about that. Mario's just dealing with something came up on the break. He's jumping right back in his office right now.
Yeah, no, I get it.
Sorry about the delay.
I was dealing with stuff in my office.
See, there you go. Good chance to catch up on other work.
It doesn't go away.
It never does.
All right, guys. All righty. So, hello? Did you guys hear me?
I can.
Okay. If you don't mind, just 1 second. I actually just had my outline in my hands, and I think I left it somewhere. All right. So, I want to ask about your role as the assessor. What do you believe to be your role and responsibility as the assessor?
That sounds like a job interview question. My primary role is to measure and value every property in the town of Connecticut and be fair and equitable with the valuation.
What is your role and authority with respect to the townwide revaluation?
So the revaluation is run through the assessor's office. We have direct control with the reval company. It is eventually my signature on the grand list. So I am the one that basically is certifying all values, no matter if it was the reval company or whoever that actually came up with them. But yeah, I mean, it basically runs through this office. We set the rules and guidelines and help the reval company in any way we can to get the best outcome possible, most fair and equitable outcome possible.
What is your role and authority with respect to the Board of Assessment Appeals?
So the BAA is a separate entity. In the past, my role has always been to meet with the board beforehand, go over any of the individual appeals, basically give them any documents or anything that they need, basically tell them how we came up with the value, what we think it should be, and then let them meet with the appellant and make the decision, having both sides of the coin in front of them.
With regard to the BAA, does the assessor's office provide staff support to the BAA?
That's town dependent. Some towns are totally hands off. The BAA does their own thing. If they go into the assessor's office, they can get what they want, but the assessor's office does not take an active role. Other towns, like in Wallingford, when I was employed there, it was me and my peer, my coworker, were designated to come up with a memo on each property and saying, this is what it was, this is our research, and this is the value that we came up with, and to provide that to the board. So it is independent to each town.
But what historically, prior to coming in, what did you understand to be the interaction between? What did you understand to be the interaction and also the staff support of any from your office to the BAA?
For Enfield specific, my assistant was always the secretary. She's the one that set up all the hearings, the meetings. She was, even though I am listed on the charter as the liaison with the BAA, she has always acted in that role. Well, not always, but my predecessor was, before she was the assessor, she was actually the liaison. But Vicky has been doing it for quite some time as the liaison. And then my expectation, I don't know what, I mean, Della always, my predecessor would always meet with them beforehand. My understanding was anyways. That was my expectation because that's what we always did in the other towns I worked in. We would meet with the board beforehand to go over any of the appeals. If they had questions they could ask, you know, we could tell them how we came up with the values or any issues. And a lot of times it was like, yeah, I think this should be lowered. I can't do it. I don't have the authority to do it because we've already signed the grand list. They have to go to the BAA to get something adjusted. But yeah, I think you should make an adjustment on this one, you know, a lower adjustment. And other times, you know, we would, you know, give them information of, you know, we think we're right. There shouldn't be any adjustments on this.
So with regard to providing assistance to the BAA, when the BAA asks for assistance from the assessor, how do you handle that?
Depending what the assistance is. My assistant was always, like I said, the secretary. But the hearings were always at 4 or 5 o'clock in the afternoon. So she was able to, the town allowed her to be the secretary, you know, even though she was being employed 9 to 5 here in the assessor's office. Or this year, elected to change their hearings to be in the middle of the day from 1 to 6 p.m. My office is short-staffed to begin with, and you know she is being paid another job, her regular job. So she was not allowed to be there at the BAA hearings for 1 to 5 to be their secretary. She could go there after 5 o'clock, and there is a different line item. She would be paid out of a different line item in the budget for her time working for the board. So that created a conflict too, is you know which one she's working for, where she should be paid from. She certainly doesn't want to take a pay cut by working 1 to 6 for them at a different rate than what she does here. So we did set, you know, you guys, that one of the reasons how the whole recording thing came up is as well, you know, we can just record the hearings and stuff and everything, and that way we can get the transcripts from the recordings. My initial thought process on the whole recordings was that each one, once we found out they were going to hear them separately, they would each just have their own recorder. They put it right on the table in front of them, leave it on, they don't have to do anything with it, and you know, each hearing would be recorded. Obviously we got pushback about the whole recording thing and stuff and everything, so that's how the whole part of the mess got started and stuff and everything, where we had to go there individually, you know, 3 different people with the individual recorders to record the hearings.
Tell me more about the recording of the BAA hearings since you've been in Enfield.
So, I mean, as I just stated, I mean, it was my thought process is that because there was, they were going to be hearing him separately, individually, you know, that they would actually be able to use the recordings when they met to deliberate. They could actually take their hearing, the recording, and listen to it back if they had to refer back to something. You know, it was actually trying to help them out as well as the town and to preserve the records. But my initial thought process was to give them each, you know, their own recording device. They would have it in front of them, just them and the appellants. I would not be in attendance. My staff wouldn't be, except for, you know, if Vicky needed to be there for, you know, helping out the process of getting people seated and stuff and everything, that portion of it and stuff and everything. But my initial process wasn't to actually be in the hearings with them. When I started getting pushback that no, we're not doing this, it became obvious that, you know, this office was going to have to step up to actually do the recording, to have somebody there to have it recorded. Otherwise it wouldn't be done. And as you saw, if you know, I mean, you listened to the recordings, they were very secretive. Didn't state anything, you know, hey, you know, this is hearing yada, 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 John Smith, this is what we're doing. You know, they talked very quietly. Certainly seemed, my impression was that they were basically trying to hide what they were doing, or not being very forthcoming. I mean, in some of the minutes, you know, Tom states that, you know, these are private, you know, we wanted to have a zone of privacy, I think was one of his terms. These are public hearings. There is no private in a public hearing. you know, he didn't want us close enough to be able to hear because some things were privileged. While it's a public hearing, nothing's privileged at a public hearing. Whatever you say is, you know, out there for the public. So I think his thought process was a little flawed on that side. But that's where my whole process started. I mean, that's how I thought it was going to happen, and then it morphed into what it did.
I want to talk about the townwide revaluation. When was the townwide revaluation?
2021 started in 2020 before I was here, so I came in at the tail end of it.
Who was responsible for selecting the revaluation company?
The town was. I don't know who actually made the final decision. I mean, Della, my predecessor, was here when the decision was made. I don't know if she was the deciding factor or if somebody else was. But
Did the town issue an RFP or RFQ?
they did.
Why do you know why the town selected Vision?
I do not. I mean, they've been doing the town for multiple years, so I'm sure that had a large percentage in it, but I'm not privy to why they hired it.
Has the town used Vision in previous? I'm sorry, you just told me that they use Vision in previous reval cycles, correct?
Correct. I was actually working at Vision here. I mean, I actually did the reval on the other side of it, working for Vision.
In
Remember it.
Enfield?
In Enfield.
And when was that?
Probably 2000, either 6 or 11.
And what did you do?
Data measured the commercial properties as well as help set the values at the end of the revaluation, at the end of the process.
So is it fair to say that you were involved with Vision's revaluation in Enfield during one particular revaluation that took place around 2006?
It was 2006 or 2011. It's probably more likely 2011.
Okay. So is it fair to say that your recollection was that you remember that you did work while you were at Vision for a revaluation in Enfield? Your recollection that it was 2011, and in 2011, what was your position with Vision? Were you a data collector or a different
I was
position?
staff appraiser at that point.
You were staff appraiser, okay. So is it fair to say that you had an active role in the revaluation at that time in Enfield?
It is.
Was it helpful to you when you took the role as the assessor to have had that experience working with Vision and performing revaluation services in the town of Enfield in 2011?
Certainly. I mean, I probably walked in 90% of the commercial buildings here. I've probably been inside. Whether I remember it or not is one thing, but yeah, it definitely was a benefit.
Has the town received any complaints about Vision with regard to recent revaluation?
Define complaint.
Has anybody made a complaint about Vision's work in the current revaluation?
Well, anybody that would have appealed to the BAA for their real estate is basically making a complaint about the reval.
No, but well, not necessarily. I mean, they're contesting the value, but let me ask you this: did anybody, to the best of your recollection, did anybody specifically make reference to Vision, to that company and the work that they did in the most current revaluation?
Not that I'm aware of or can recall that anybody specifically came in and complained about the reval company.
Okay. Do you know if there's been any complaints about Vision in the past with regard to its work, doing reval work in the town?
Not that I'm aware of. I do know at some point in the past, and this is probably off topic, maybe, that there was a little court case here. Is that a Vision data collector? This was after I left. There was a data collector here that got arrested. She or he, I'm not even sure the gender, knocked on a door. This is what I was told. Knocked on the door, nobody answered. They started going around the house to measure it. The person was inside the house, came out. I'm not sure if they had a weapon or not, but basically called the cops, had the person arrested for trespassing on her property. And I believe she was either in law enforcement or a correction officer.
Mhm.
And it actually went to, it actually proceeded to go into the courts. And from what I was told, the court just looked at it and says, why are you guys even here? She was on reval. She had the right to be there. Should have been quashed at the chief of police should have never even prosecuted anything or did anything at that point in time.
So, but as far as any complaints about Vision in the current reval, it's your understanding, you don't have any recollection of anybody complaining at this time. Is that correct?
I do not.
Okay. Did you have an opportunity to review Vision's report for the revaluation?
I did.
And what, do you have any thoughts about it?
Yeah, I mean, I reviewed it with the right personnel, the project manager to go over it, the commercial appraiser that was here doing the commercial side of it. We reviewed everything, went over certain properties that I thought should be adjusted or had questions on. But everything was meeting the the state of Connecticut statistical method. It was meeting all the standards. It was meeting all the CODs and the PRDs and all the metrics that they put on for the reval fell within guidelines.
Okay.
So, and like I said, Vision has done this town probably for a few decades now. So they're very well familiar with the properties. It's basically a pretty simple reval. It's just checking the current market and adjusting the value. So it's not really a complicated process, relatively speaking, for a reval.
Did you have an opportunity to review a report on the decisions of appeals of assessments heard in April 2022 and decided in May 2022? The document was dated May 28th, 2022, and it was issued by, looks like, the Enfield Board of Assessment Appeals.
What was the date of that one? May 28th?
Yeah, it was a substantial document that was submitted by the BAA.
I mean, I reviewed. So this is the May 28th schedule I have, but it's only 2 pages.
There was, let me show, there's a document. You can see it. It was a document that was provided by the BAA. It was like a substantial report that they gave.
Is the heading supplemental report on decision of appeals and assessments?
This one says Enfield, Connecticut Board of Assessment Appeals report on decisions of appeals and assessments heard in April 2022 and decided in May 2022.
That one says the supplemental.
The town manager described it as a manifesto. It appears to be a report.
Yeah, if it was in the meetings, I'm sure I just wanted to have it in front of you.
Do you have a copy of it handy? Otherwise, we could email it to you.
I do. I just have to find the right one.
Take your time.
Not the one that states the second record. Right? Enfield, let's see, Enfield, Connecticut Board of Assessment Appeals, report on decision of appeals of assessments from April 2022 and decided in May 22, May 28th, 2022.
Yes.
The right document?
Yeah.
First paragraph is started with background.
Mhm.
Yep, I got that one. I have reviewed that.
So on page 1, do you see where there's a statement in bold stating Vision's report, we conclude upon the BA's review of Vision's report, we concluded that it was more than just a little flawed.
Yeah, that's bolded. Yep.
Was it your understanding that long as did you was your understanding that the BAA was critical of Vision's work with the revaluation?
I was aware of that, yes.
Aside from the BAA, so the BAA members obviously issued this report and were critical of Vision's work. Do you recollect whether anyone else submitted anything in writing which criticized Vision's work?
Not that I'm aware of or recall.
Did you have an opportunity to review this report that the BAA issued?
I have read this, yes.
Okay, so do you believe that Vision's report was more than just a little flawed?
I do not.
Why?
As I stated, I mean, they've been in this town for multiple years. It's a fairly simple town as far as revaluations and values go. I was involved in the end process of, reviewing all the commercials, the grand scheme of the residentials. There wasn't a lot for Vision to do besides update the current market. All neighborhoods have already pretty much been set. There was actually only one change to a neighborhood because there was different market factors involved. We've, like I stated, we fell within the guidelines, well within the guidelines for the state mandated procedures, statistical numbers. There was nothing to indicate that was anything that was flawed. As an overall scheme, I mean, is there certain singular properties that might have something wrong with them? Sure. I mean, that's going to happen in any reval. It's a mass appraisal, not a fee appraisal. But as an overall scheme, no, it certainly wasn't flawed.
If you look at page 2, there's specific reasons that the BA cited were the basis for their statement that that Vision's work was flawed. So one issue that the BA brought up was that Vision stated in its report that its determinations were influenced by interviews with knowledgeable local brokers and real estate agents. And then the BAA stated in its report that statement from Vision was false and misleading, that there were no local brokers or real estate agents that Vision interviewed, rather to the extent that they did just have communications or conversations with a broker or real estate, it was limited to a woman from Wallingford. That she was the sole person identified by the tax assessor as representative of the local brokers and real estate agents interviewed by Vision. Are you aware of this claim that the BAA made?
I'm aware of it, yes.
Is their statement that no local brokers and real estate agents were interviewed by Vision? Is that accurate?
I reached out to Vision, asked them this question because I wasn't aware and I wasn't involved in the in the beginning of the process. In my experience on the revaluations, there's not really any brokers that are talking to. You're looking at the current market, what things are selling for. You're doing the income and expense reports to get current market rents, rates, vacancies, expenses. If you have specific questions about a certain property, if you're looking to do construction models, you might talk to a broker, but in my experience, I mean, I've never talked to a broker when I was working for Vision. I'm not sure if any of the project managers did. I don't know that it's necessary. Usually the cost models are taken out of a cost book like Marshall and Swift, unless there's a specialized property where you might be talking to somebody local. I mean, that statement probably should just be taken. It's probably been in there for years and probably should be removed. But my recollection is that Vision gave me this person to give to the board as who they talked to.
So is it fair to say that in fact Vision confirmed that they really only spoke to one person who was one broker who was out of Wallingford?
Right, correct.
And so therefore, would you agree with the BAA that the statement that Vision made that their determinations were influenced by interviews with knowledgeable local brokers and agents was not accurate and should not have been included in the report in Vision's report?
I'd probably agree with that. Yes.
The second the second issue cited by the BAA was that there was that with regard to Vision, there's a failure to provide consistent depreciation schedules for residential as well as retail properties. It was likely detrimental to retailers in that it was during the middle of COVID. Very few people were shopping. A lot of people were shopping online. An updated depreciation schedule reflecting retail cap rates for FY21 would be more fair and accurate. I don't particularly understand what they're saying here because depreciation schedules I mean, depreciation schedules I would assume would be used in a cost approach, and they seem to be conflating depreciation schedules and cap rates.
So I don't know. I mean, this is informal, and I'll state this. We should have had the grand slam of BAA members in Enfield here. I mean, you have a commercial appraiser, you have a tax attorney, and I think the other one's a real estate agent. They should have been very knowledgeable. Working with Vision, it's very difficult for a fee appraiser, a real estate agent, somebody coming from a bank that does that type of appraisal to come into the mass appraisal side, because they are two totally separate entities, two different approaches on how properties are valued. And this just goes to highlight that they have no clue how a mass appraisal works. You're right, it's very confusing. I'm not 100% sure what they're trying to get at here, but it does look like they're looking at cost and income. A revaluation is over a 5-year period. So you'll certainly 1 year is in consideration, but it's not the only consideration because it's a 5-year period. If you're in Massachusetts where they value it every year, COVID certainly could have had an impact that 1 year, but then the following year it's going to be another reval, new values in Connecticut.
By the way, not to interrupt you, but just to help you, if you take a look at their report, there was an exhibit 2 that they have there. And actually, if you don't mind, what I'd like to ask is this, Todd. I want to give you a few minutes just to read this to refresh your memory. Take a look at page 2, the third issue they cite, which is this creation of the Fountain of Youth. I want to ask you about that. And then just do me a favor, take another review of this report. Why don't we take a 10-minute break? Let's resume at I want to say 12:20. Let's resume at 12:30. Let's come back at 12:30. Take a look at this report because I want to ask you about it, and take a look at it. And this way, it's fresh in your mind. And we can kind of run through it quicker. Is that all right?
Sounds good. Yep.
All right. And if you want to take have your quick sandwich or something, it's probably a good time to do that as well. So let's circle back at 12:30.
All right. Sounds good.
Thank you. Bye.
I'm ready if you guys are.
All right. You all set, Todd?
I am.
All right. So, did you see the third reason stated by the BA, this creation of a fountain, with regard to why they thought the vision report was flawed, and that was the creation of a fountain of youth formula?
Yes.
Did you look into that accusation made by the BA?
Yes.
And what did you do? Did you reach out to Vision to confront Vision with regard to that allegation?
No, I mean, I didn't need to. I mean, it's a normal course of a revaluation. If the board would have researched it before, it happens in every revaluation, not just this one. So the previous 3, 4, 5 reevaluations here in Enfield and every other town that's done a reevaluation, the effective year built value changes. This is what they're calling the fountain of youth, where the effective year built actually increases instead of decreasing like a depreciation. So as I started to say, they're looking at it on a fee appraisal basis, not a mass appraisal basis, and they're looking at depreciation and confusing it with effective year built.
Well, but let me ask this, because this one actually I'm a little curious about, because I understand on point 2, it seems like they're conflating depreciation and the cost approach and income approach. But here, when you have those field cards on the field cards, it's going to say what the effective. So, for example, on residential, you're doing a sales comparison. On residential, you're doing a sales comparison. It's a modified cost approach, right? You're doing a sales. You have sales, and the revaluation. You have sales, and then they're taking those sales and doing a cost approach for each property based on the sales data. Is that correct?
Yeah, they're basically backing into the cost. Yes.
So, would you agree that a revaluation with regard to residential does a modified cost approach?
Sure.
Okay. So, when you have a field card and it says what the effective date of the property is that a data point that affects the valuation?
It is not.
Why?
It's more of a metric. It has no bearing. There's no tables, cost models set up on the effective year. I don't want to say there's no tables. Obviously, it run off a table, but there's no value attached to that. The only thing that the depreciation and the year built and the grade of the building, the condition of it, is the driving factors of the value.
So now they cited that some of the properties changed from average to good. What category are they referring to? With the average and good, is that building condition? What category is that?
Right, that's the building condition.
So with regard to building condition, if the building condition is improved, does that potentially increase the value?
It does.
So they've stated here that there are properties where there's been no work done and the property condition went from average to good. Are you aware of any of those cases?
Not in particular, a particular property, no. I mean, but if somebody's maintaining their property, they don't necessarily need to, put $50,000 in there if they're maintaining and repainting and keeping up on the property. And this is, the field reviewers' assessment driving by the property and on what the condition of that property is. And the condition is the exterior of the property as well as the interior. They should be taken in combination. It was the field appraisers' view that that particular property, whichever one they're referring to, was in good condition for the age of the building. So a brand new 2022 building is going to be in average condition because it's a brand new. That's what you would expect to have for a brand new building. 1900 house built in 1900 in average condition, you would go in there expecting uneven floors, doors that might not close, but that would be an average condition for a 120-year-old building. So they're really conflicting or combining two different things here. They're doing depreciation, well, three different things: depreciation, actual year built, and the effective year built. I mean, there's three different things here that they're combining that really shouldn't be.
But how would so it seems like, is your explanation that you believe that the reason that if you have a property where the house hasn't, no work has been done, yet the condition's gone from average to good, and no work has been done and the effective age is gone down, not up, that you believe that was a result of a different person at Vision looking at the property and making a different independent assessment of it, and therefore determining it.
It was certainly the field appraiser that made those decisions, whether it was average or good, as far as condition goes. I didn't really have an individual hand on looking at those, the 16,000 properties here. That was a Vision personnel field reviewer making that decision. So on this, the effective year can go up. So basically, a house is going to have a 40-year life, or a 60-year life, depending on how the schedule is set up. But if you're maintaining that property, doesn't if you and you're keeping it in good shape, and I don't mean good by redoing the kitchen type stuff and everything, but keeping the rot away and fixing minor things that get broken and stuff and everything throughout the years. That house is going to last longer than that 40 years. So that's how the effective year actually can raise, go higher, because now you're prolonging the life of that property, not by doing anything besides regular maintenance and fixing things and, replacing the furnace after a 20-year life or replacing a roof or something like that. That effective year, you're prolonging that 40-year life. Now it's going to have a 50-year life or 60-year, obviously I just mentioned there's, houses out there that have been around for 100 years.
But is it fair to say, when I had asked you earlier about whether you had discussed this with Vision, I think you said you did not. Is that correct? This concern that was raised by the BAA about the fountain.
So I had a conversation about what the board was doing with the effective year, but I was fully knowledgeable on the situation to begin with. So it's not that I didn't talk with them, but I didn't talk with them to get their input on how it worked, because I already knew how it worked.
All right. So is it fair to say, with regard to the allegation that the BAA made about the fountain of youth formula, I just want to make sure I understand what you did. It's my understanding you said you did not contact Vision to inquire about what they did with the changes with regard to effective age and condition of the property. Is that correct?
Correct.
All right. And so the explanations that you're providing with regard to why you believe it happened potentially is based on your understanding in general of how revaluations work, and not with regard to any specific knowledge of what Vision actually did here in Enfield for their reval. Is that correct?
Correct. It's standard practice that happens in any reval throughout the state.
Is it fair to say that in hindsight, it may have been worthwhile to at least have contacted Vision to inquire about what they did with regard to changes in property condition and effective age, in order to be able to properly address this issue of concern raised by the BAA?
No, I don't believe that's an accurate statement. I could have addressed it if they had actually asked me. They never have actually reached out to me to ask what the explanation was and why the effective year changed. I've never been asked by the board.
Well, but the board did provide a memo or a report on with regard to the revaluation and you were provided a copy of it, correct?
I was, but
Okay.
The board will not talk to me.
Okay. I can imagine that's frustrating. So I think I'd like to know from somebody at Vision what they did here, and I think we're going to probably end up. I think I have to. I'm going to have to interview somebody from Vision. So, who do you think would be the most appropriate person for me to interview with regard to the revaluation?
Yeah, you could contact June Perry. She's the project manager on the project.
Who's that?
June Perry. I'll have to get your number, or you can call Vision directly.
Would you mind sending an email to June and just letting her know that the town's asked me to look into various things that were done with the revaluation because of questions raised by the BAA and others. And I'd like to have an opportunity to interview her to ask her about the revow.
Sure.
And then just, just introduce the two of us over email and then tell her I'm going to give her a call and I'll give her a buzz and I'll give her some more feedback. I'll give her some background and let her know what's going on and what we're doing.
Sure.
So that I don't want somebody to be blindsided.
Yep.
But
So
I've never
just-
met her. I've
Okay.
never met her before, so at least this way you could at least introduce us over email.
Yeah, no, I'll CC you on the email.
Yeah, if you just give me her number, I'll give her a buzz. Or
Yeah.
she could call me.
And just to be clear, the EYB, the effective year bill, has no effect on value.
So the effective year bill has no effect on value, but the condition does.
The condition and the year bill does.
And by the way, just because the BA is saying that some of the properties went from average to good without any change to the property doesn't mean that's actually what happened. I don't know. I mean,
An individual property, sure. I mean, that there is an opinion by a reviewer. I mean, it's
well, just because, by the way, just because somebody didn't get a permit doesn't mean they didn't do work to their house either. First of all, the work may not have been eligible for a permit, and second, or require a permit, and second of all, it could have required a permit and they just didn't get it.
correct. Yeah, very true.
But doesn't mean that you can't assess the new work that was done.
We were supposed to assess what's
Or
there.
what's there, and so. All right. So on page 2 and 3, the BA references a meeting in which they engaged in a conversation with you regarding your background, experience, etc. So they said that there were several observations they made. The first one was that you were knowledgeable about your understanding of agriculture, farming, and PA 490. Okay. The second is that the first one was that they said that you were boasting. Although boasting of being so knowledgeable in his understanding of agriculture, farming, and so intimately familiar with the language of PA 490, that his expertise in this area was recognized at the state level, he claimed to have been appointed to some committee to rewrite 490 laws. I don't understand what the point. Okay, so I don't understand.
They asked me what my qualifications were. I basically stated the same thing that I stated here earlier. I didn't say that the state recognized me. They recognized the committee. I'm on the committee, so
I just asked you about that, and I didn't, for the record, I didn't consider you to be boasting. You're just telling me what you knew and how you knew it and what your experiences. So okay.
Yeah, it was basically
second thing was they said you touted yourself as an appraiser. When you had that meeting with them, did you tout yourself as an appraiser?
No, I've never been an appraiser. I never claimed to be. No.
You told me earlier about your what your credentials were and experiences with regard to valuing property. Did you tell them in that meeting that you were qualified to reclassify agricultural land based on your prior experience?
To my recollection, what I probably would have said is that is the assessor's purview to look at all PA 490 land and classify it.
And did you tell them that based on your experience in farming and landscaping, that assisted you with making determinations as to whether the land qualified as under PA 490?
I would have certainly said that. I would have said, according to state statutes, whether it qualified or not, whether it's still being actively farmed. I would have indicated I reviewed all the previous applications.
Did you ever tell them that you were a soil scientist?
No,
Did you ever tell the BAA that you had any specific credentials with regard to evaluating soil in Connecticut?
no, that was solely brought up by the chairman.
And how was it brought up?
They came out and directly asked me if I was a soil scientist. Which, to be honest, somewhat baffled me. It was out of the blue.
So they said that you described how you interpreted and applied the provisions of PA 490 to Enfield's real estate. Did that take place, that discussion?
Yes, as I just stated, I mean, I would have, applied it according to state statutes.
Did you, in that discussion with the BAA at any time, express that you had a disdain or disdain for PA 490 exemptions?
No, I did not. As I stated, I mean, I grew up a farmer.
Did you, during that meeting, inform the BAA that you had a concern about the purpose and intent of PA 490 exemptions in Connecticut?
No.
By the way, was this meeting that you had with them taped?
It was not. I mean, it was the very beginning of our relationship. So, I mean, I had to purchase the recorders, didn't even have anything, in hand. It wasn't done intentionally. I just wasn't prepared to be taping at that time. Didn't have the equipment and I wasn't planning on taping all the BAA meetings. I was planning on having them tape their hearings with the taxpayer.
They bring up in their report that you attending BA meetings. So when the BA started having their hearings, did you start to appear? Did you start to go to those hearings?
I did.
And why did you do that?
Needed 3 people for the recordings. It's a small office. We only have 4 people, well, 3.5, 1 part-time person. So didn't have a lot of options of people to actually be there to record the hearing.
And when you say record, what do you mean by that?
Record as each individual, because they split into 3 separate groups. Needed 3 people to be able to record each one, which basically meant going with a little handheld, looks like a little flash drive recorder, and sitting in the room to record the hearing.
But the state law does not require that you tape the hearings. Is that correct?
Correct.
And the state law require that that somebody be there to record, to even let me ask this way, with regard to the BA hearings, the BA is required to have meeting minutes to create a record of what took place at the meeting, correct?
I would say yes. I mean, I'm not an expert on public meetings, but yeah, I mean, my knowledge, I mean, all public meetings have to have minutes and, be recorded in a certain time frame.
But from my experience, you have, so it sounds like first of all, it sounds like in Enfield, from my experience, either BAs, all 3 members sit and hear every application, or what they do is they split up, and they, especially in a reval year, and each individual member sitting on the BA for that particular meeting will each take a stack of applications and hear an applicant's appeal, and then take notes, and then report back to the larger group in their deliberation session. Is that what happened in Enfield?
It was.
Okay, so in my experience in other communities that do that, when I go and meet with an individual BAA member, it's just me and that member. It's usually not a staff member from the assessor's office sitting there to either record or to listen. Is it Enfield's practice to have someone from the assessor's office there to either listen, to take notes, or to tape it?
It was not in the past. In the past, my assistant was always the secretary, and she was the one that would sit there. So there was somebody from the assessor's office acting as the secretary for the BAA, taking all the minutes. I believe, and you can ask Vicki on this to clarify, because it wasn't before my time. They did separate one other reval year, and she took the notes for all of those.
So just to get that straight. So when they divided into three separate members meeting in either, different parts of the room or in different rooms, that Vicki listened to each one of those, or because she can't be in three places at once. So
In the past, what I was told, what Vicki told me is that she would ask them what they said and she would record it.
Okay, so basically what the practice was, each individual correct me if I'm wrong, my understanding is then the practice was that and we could verify this with Vicki, but that each individual member of the BA would report back, I met with, Mario Capola about his application on 1 Smith Street. Here's what we discussed. And then Vicki would reflect that in the meeting minutes. Is that what happened?
My understanding is the majority of the hearings throughout the years, not, throughout the different grand list years, all three would generally meet together. They would, and Vicki would sit in, and she would be the secretary and take notes and do the meetings, do the minutes. I believe there was at least one instance where they did separate into 3 separate individual hearings. Each one heard a different taxpayer. And at that point, Vicki asked them each individually what they said, and then she made the notes on doing it that way.
And was your preference to have a staff member at each of those hearings to hear what happened, or to tape it so that was that your suggested practice?
My preference was to give them each a flash drive recorder, put it in front of them for each hearing, and to have no staff there unless Vicki was there to, do other duties. That was my preference.
And what happened when you made that suggestion? Did you make that suggestion to them?
Well, they basically told me they weren't recording. So that was their, they said, we're not recording the meetings.
Did you ask them to record the meetings?
Yeah, well, I basically we put out a statement saying we're going to record the hearings.
And then what was the response from the BAA?
They basically came back and straight out said, we are not recording our hearings.
So did anyone from the BAA at some point raise a concern to you about you watching the BAA hearings?
So the only interaction I have had with the board was this one meeting where they interviewed me about the whole soil scientist thing. Other than that, they have either refused or been unwilling or just don't want to talk to me. So the board has not raised anything to me.
At some point, so how many hearings did you end up hearing? I mean, did you end up watching?
Oh, I don't know. I mean, I went to the first 3, 4, 5. I don't know the exact number. I went to the first ones. Obviously, I was in contact with the leadership here, town manager.
How many meetings did you? Approximately how many BAA meetings did you attend to watch?
What was the last part? How many meetings? What?
How many BAA meetings did you attend to be able to observe the hearings?
Well, like I said, I'm not sure of that number. It might have been 3, 4, 5. I'm not sure the exact number I personally attended.
Is it fair to say that your recollection is that you appeared at approximately 3 to 5 BAA meetings, during which time you observed the hearings?
It's fairly accurate. Yeah, I mean, it's yeah.
So when you observed the hearings, did you tape those hearings?
I did.
And did you do anything with regard to did you assist with the meeting minutes for any of those meetings?
I did not.
At a certain point, did you stop attending the BAA hearings?
I did.
And why why was that?
While talking with leadership, town manager, and the way they were doing the hearings, it was decided it was more contentious me being there, so we just had a different staff member go instead of myself.
And you said discussions with leadership, and you mentioned the town manager. The decision, with whom did you, within the administration or leadership of the town, with whom did you discuss the issue of whether you should continue to attend the meetings?
Town manager.
And so is it fair to say, did you get input from the town manager with regard to whether you should attend those meetings?
Yes.
And what was her input?
She thought it would be better if I wasn't there because I seemed to be the sole contention that the board had.
And so did you inform the BA at some point that you were not going to attend any more of their meetings?
I did not.
Did you stop attending meetings at that point?
I did.
Can you please take a look at page 7 of the BA report where it says where land purportedly was sold or transferred?
Okay.
Are you aware of the claim that the BA has made with regard to your actions pertaining to the sale or transfer of land?
I am.
Okay. And what do you understand to be their claim?
My understanding of what they believe to be true or their thought process is that if it's a family transfer and an accepted transfer, that it stays in the PA 490.
So is it fair to say that the issue is how you would handle the transfer of land by family members in a manner that would affect the continuation of the PA 490 exemption?
It is, but there's other guidelines that have to be followed. So, I mean, that's an abbreviated, just because it is a family transfer does not automatically transfer, continue the PA 490 status. It's not automatic.
So is the BA referring to specific cases in which you took away exemptions for properties that had previously had a PA 490 exemption on the basis that there was a sale or transfer of the property?
Yes.
And what properties were they referring to?
I'd have to look up at the individual ones. I mean, there's multiple. Some of these properties had 3 or 4 transfers, sales, transfers. I believe they're misunderstanding of the accepted transfer meaning. The only thing that accepted transfer means is that you don't lose the PA 490 status. It doesn't start from day one, from whenever it was first on. That's the date that it starts from. But there's other requirements as well, whether it's a sale or a transfer, in that you need a new PA 490 application by the new owner to be submitted to the town within the stated guidelines, the dates. If it's a forest designation, not only do you need a new forest application, but you also need a new forester's report if the last one was dated more than 10 years ago. So just because there's a family transfer does not automatically transfer that over into continue the PA 490 status. The owner has to notify the town, specifically the assessor's office, that, hey, we own this property now. And if they don't do that, then they lose that PA 490 status.
this report on page 7 and 8 makes reference to actions that you made to overturn previous decisions by your predecessor assessor with regard to prior transfers of the property that took place prior to you being the assessor. Are you aware of that allegation?
I am.
Could you tell me what you understand to be that allegation that the BAA has made with regard to your involvement here?
My belief of what they're stating is basically that if the previous assessor, when the transfer happened, say it was in 2010, and the assessor at that time didn't remove it, then it's something that the preceding assessor can't change.
Do you agree with their position?
I do not.
Why?
Just because either a mistake or an inaction was done in the past does not mean that a new assessor can correct that.
Now, so is it your position that you would have the right to go back 3 years to make a change pursuant to Connecticut General Statute 1260?
So 1260, I believe, is the clerical mistake.
Mhm.
This does not fall under 1260 because it's not a clerical mistake. It was a conscious decision. It wasn't a typo or anything like that.
That's where I was going. Okay. So in their report, they make reference to 1260. Did you change anybody? Did you take away any exemptions based on a previous sale or transfer of the property under your authority under 1260?
I did not.
Okay. So when you stated that you did take away some exemptions based on previous well, let me ask this. Did you, I just want to make sure I get this correct. Did you remove any exemptions under PA 490 for previous transfers or sales of the property which took place prior to you being the assessor?
I did.
And in those cases, did you take the exemption away as of the current grand list year, or did you do it retroactively for prior grand list years?
The current grand list year.
So is it fair to say that if a sale took place 3 years prior, and they maintained an exemption for 3 years, you didn't take it away for the previous grand list years, you only did it for the current
Upcoming.
grand list year, which you were signing, the upcoming?
Correct.
Okay.
And it should be noted, I sent letters to all these people asking for the correct information.
So I don't know the answer to the issue, the question that I'm gonna, or the issue. We're gonna have to research it, but would a property owner have a argument that they have a vested right to continue the exemption for PA 490 where the transfer took place and the previous assessor agreed that that transfer did not invalidate the PA 490 exemption, that a new assessor years later cannot go back and change that decision that was made for a prior grand list year? Do you believe that a property owner, that would be a valid argument to continue the exemption and to not allow you to overturn it based on a previous transfer or sale?
So I believe it's an argument that somebody can make. I believe it's an argument that has been made on open space. There's been a court case in Bloomfield, it was before my time there, on open space, that just because somebody had the exemption prior does not grandfather them in allowing them to keep that exemption if something changes. That has been ruled in the state courts for open space. I believe it would follow through thinking with the farmland. Just because something was done in error, by mistake, by inaction, just somebody wasn't doing their job properly, does not. And I believe the courts have upheld this in other instances besides PA 490. Just because somebody didn't do something in the past does not negate a new assessor from fixing that issue.
So, and I apologize for the multiple homework assignments, but I'm going to give you one more. In a separate email, could you, what?
You know, I'm in the middle of signing the grant list, right?
I know you are. I know. And I'm saying it's not lost. Believe me, it's not lost on me that the timing is not good for you. And I do appreciate that, and I hope you understand that.
I do.
One of the problems here was that the town had reached out to me in the
Yeah.
summer to retain me, and then didn't, and waited and went through a process, and then we didn't get retained until I think September maybe ish.
And then you got busy. I know, I'm aware, yeah.
Yeah, it was just a busy time of year, and so I get it.
What do you
And
got?
then but anyway, so my next homework assignment is could you provide us a separate email with those properties in which you um, took away a P90 TA 490 exemption solely on the basis that there was a previous transfer or sale, not a current, not within the grand list year which you were dealing with, but in a previous year, where the previous assessor determined that that sale or transfer didn't, either she ignored it or determined that it didn't affect the exemption, but you went back retroactively and determined that it did. I can't believe there's that many of them. So would you be able to provide those to us?
That's easy. I have a spreadsheet on all the reasons why I removed.
Yeah, but just well, if you could actually pull out the one, here's the ones where I did
No, it's
this.
easy. It's in an Excel spreadsheet, so I can easily manipulate, do whatever I want with it. So.
Yeah, and then just give us the records, like, what did you send to them, and all that jazz. All right.
I will say on page 5 too. I don't know if that was part of your outline, but significant other events about the posting. How they state that the town assessor posted something on the door about the recordings.
Yeah, let's go there. I mean, that's fine. So let's talk about page 5 of the BAA report. There's a part of the document which says significant other events on page 5. Do you see that?
I do.
Did you post a note on the door before the BA hearings on April 5th, 2022, informing the public that the meetings would be recorded?
I did not.
Was that done by anyone?
It was done by the town manager's office.
And why was that done?
You can ask Ellen, but she informed me from my recollection is that she wanted to get ahead of the board because they were basically making a statement before every hearing that the meetings were being recorded. So she just wanted to help, I believe, inform the public that they, meetings were going to be recorded. But you would specifically have to ask her. I was unaware of it until it was, it was already done by the time I found out about it.
And do you see the allegation set forth on page 5 with regard to the mailing out of a questionnaire on behalf of by you on behalf of the BA? Do you see that?
I do.
And do you see the document which they attach as Exhibit 5?
I do.
Did you or did you instruct somebody in your office
I did not.
to mail out that document?
I did not.
Did anyone from your office mail out that questionnaire to appellants who were participating in the BA process?
They did.
And who did that?
My assistant assessor, Vicky.
And did you direct her to do so?
I did not.
Why did she send that questionnaire to appellants?
It's been the practice in the town of Enfield to do that in previous years. It's been done, I don't know how far back, but she's told me that she's always done that for every BAA hearing. I wasn't even aware of it until this afterwards. But it's normal course of business over the years to send out that. Which, in retrospect, this board should have known.
On page 12 of the BA report, there's a heading that states assessor's methods used to obtain motor vehicle information from property owners was very disturbing. Are you aware of this allegation made by the BAA against you?
I am.
Did you see the form that they attached as Exhibit 10?
Yes.
Did your office send that document to taxpayers with regard to motor vehicle assessments?
We did.
And did you create that form?
I did not.
Your name is on the bottom of it. It says, "Thank you for your cooperation, Todd Helems," correct?
I filled in the blanks. The template form was not created by me.
Who created the template form?
This is part of the Vindicode program that helps identify larger vehicles, combination vehicles, incomplete vehicles, dump trucks, cement mixers, garbage trucks, and so forth.
And we talked about, in order to expedite this process, we talked about you sending, or I asked you to send us a separate email with
Right.
the, I'm going to mispronounce the name, what's it called,
Vindicode.
with the Vindicode process and what you did there, and you're going to send us something, right?
I am, but this is a form. This is a template letter that was in the program to be able to send out for the vehicles that we needed more information on.
So in the template document, it says the state motor vehicle department has notified our office that you recently registered the below vehicle. With regard to those taxpayers to whom you sent that form, that form document, was your office informed by the Department of Motor Vehicle that that taxpayer had recently registered a vehicle?
So that's the part where we could have done a better job. The recently, probably, I mean, that should have been reworded. We get a list from the DMV every year. Actually, we get 2 lists from the DMV every year of every vehicle registered in Enfield. So the DMV does notify us every single year, twice a year, of all the vehicles registered in the town. Now,
So
some people mistake the recently part. I mean, that should have been probably reworded because some of these vehicles have been on the list for 10, 20 years.
okay, so is it fair to say, by the way, if I look back at everything that I did, my God, I could, my wife tells me on a daily basis what I do wrong. And if somebody came here and watched what I did at work, I'm sure they could come up with a list literally
Oh.
every day about things that I could do differently. And believe me, I could give you a list of things that in hindsight, I wish Matt's smiling because he knows he would have his own list. So
And
I want to
I
make sure that
changed-
I want to make sure you understand that when I'm asking questions and trying to figure out what are things that you would have done differently in hindsight, that nobody's perfect, and that I just want you to understand that we're I'm not being critical when I'm asking, and I'm continue to ask those questions throughout this, and I hope you could understand and appreciate that.
I can take criticism, and I'm actually hoping to get some others. There's things I know I can do better without even anybody telling me I can do better, but a lot of it's time constraints or support, whatever. This here, we sent them out again this year, but I reworded it. And I mean, actually, had the town manager review it, look at it first before I did send them out. So the same letter went out this year. but it
Great.
was wording. I mean, it's,
So make it, if you make it simple for us, when you send us that separate email on this system, send us a copy of the prior notice, although we have it here, but send us a copy of the prior note, the form notice that you had, and then send us the new one and we could see what the revisions were. Okay. And I think this is an example, Todd, of, okay, you know what? There's some things that in hindsight, the assessor would have done differently. Or, you know, I shouldn't say would have done, but now, you know, with experience of the job is going to do it differently. And I think it's not, I would have done it. It's just now that
after feedback from the town. I mean,
yeah,
I mean, it's because I didn't read it that way. I mean, you know, when I'm reading it, but I'm sitting in this
I'll give you an
chair.
example. Paul Freya, I assume you know Paul, right?
Yeah,
Is the
Westport.
assessor in Westport? So sometimes he'll send me notices. Hey, Mario, what do you think? We're going to send this new notice to something different now we're doing. And almost every time I always revise it. And it's like ready to go out, and here so the bottom line is, and quite frankly, when people give me appraisals very often, and if I get a draft appraisal, I have a chance to talk to the appraiser. I haven't seen one yet where I didn't have a comment, where I didn't want some things changed. I mean, it's just not to say I could have done a better job with the appraisal, but you know, when I'm looking at it, there's things I could suggest to change, and a lot of times they're the right. So I just want you to understand that as we go through this process, and when we issue our investigation report, I presume there will be some instances in which we will state that, you know, either the assessors recognized that there's something you could have done better here and he's improved that process. We're going to be looking for some of those things, which I think are important to give people, if that makes sense.
Council's going to want something to say, hey, you know, I get that.
Okay.
And I realize, I mean, there's obviously things that can always be done better. I mean, notifications.
And by the way, I think at some point in the report, we're going to state that if we underwent this process with any other assessor in Connecticut, and I represent a bunch, that I assume we'd be able to pick apart what people do and come up with the similar, you know, a lot of similar suggestions to people. So,
right. Yep.
But I just want to give you a heads up as to what I'm looking for as well in this process. So, not a surprise to you.
I'm the first one to say I'm not perfect.
And like you said, a lot of it is time. There's a lot of things I could be a better lawyer. I could do a better job with, you know, I'm the corp counsel in Norwalk, and it's a part-time job. It's a salary. It's not like I bill hourly. It's just, you know, that's my job. I could do a better job in Norwalk if I had more time.
Yep.
I mean, and I don't, you know, I don't know how much I wouldn't want to say that publicly, but the truth is, if I had more time, I could do more. I could do better. There's things I do quickly that I could, you know, half-ass. So, all right. So the last revaluation prior to the most current one was in 2016. Is that correct?
Yes.
And that was a statistical update, correct?
Correct.
And the last reval you did was a full reval with inspections, correct?
Correct. Yes.
And the decision to do inspections on this reval, did you have any? Were you involved with that decision?
I was not.
Do you know why there was the statute requires that every 10 years, I think, that you do an inspection, that you do inspections, right?
That's not completely accurate.
No, tell me, because
so it does require an inspection, but the inspection can include a data mailer. It can be from a permit. You know, every property has to be visited within the 10-year period. If I go in year one after a reval and do a permit and I inspect the house, that counts as an inspection. If I send out a data mailer to somebody and they send it back, or even if they don't send it back, I'm actually on the committee trying to help rewrite that portion of the state statute and stuff, and what constitutes an inspection. But right now it's accepted that a data mailer is considered an inspection. So I could not visit any one of these 16,000 properties, send out 16,000 data mailers, get 50% of them back, and be good under the state under the state statute.
And so with regard to what Enfield did, Enfield actually tried to, the reval company actually tried to do physical inspections. Is that correct?
Tried to do a physical inspection, which is really becoming passe. I mean, not a lot of towns are doing that anymore.
What do you think is the best practice?
I think the hybrid, which most towns are going to, so data mailers is part of it, but the hybrid is if you know certain areas that have had big changes or you've had issues with in the past to do physical inspections, that you should pick a certain percentage. Or if you don't have anything, just pick 10 or 15 or whatever percentage you want to pull out of saying, we're just going to, inspect this 20% of the town, and we'll do data mailers on the rest. We're trying to get it into the legislation possibly of the flyovers being an inspection, or part of the revaluation and stuff and everything, because the state is starting to do the flyovers. A lot of towns are starting to do the flyovers where you can actually see the property. You can actually start doing, depending on the resolution, you can start doing measurements off those flyovers. So yeah, I mean, technology is definitely changing things. The economy is definitely changing things. Towns just don't have the money to spend $40 a parcel to do full inspections anymore. So I think it's going to be a hybrid. It's going to be a mix. Is probably the best approach. I would never do a full inspection, full walk around inspection on a town anymore, unless you knew there was an issue.
Okay. So when were property owners notified of, so let me take a step back. So you came in June of 21, correct?
Correct.
And the revaluation was already in process when you came in, is that correct?
Correct.
All right, but you were the one who had to finish the revaluation process and ultimately sign the grand list.
Yes.
And so you were in charge. Were you the assessor that was in charge when property owners were notified of their reassessments?
Yes.
Okay. So when did property owners receive notices of their new assessments in the reval?
They did.
And when were those notices sent out to property owners?
I believe it was the end of October, beginning of sometime in November.
That's early. Okay.
Was the first notice.
And did property owners on that notice, were property owners informed of the opportunity to schedule an informal hearing with the revaluation company?
They were.
If you can, next homework assignment, please send us the notices that were sent out to property owners associated for the reval, please. Just send us like 1 or 2 samples.
Mm-hmm.
And did the town conduct informal meetings with property owners in the revaluation company for some period of time?
We did.
And what was that period of time?
It was 2 or 3 weeks in December.
When you send us a separate email if you can on the notices associated with the revaluation, and if you could just confirm for us during what period of time property owners were afforded an opportunity to schedule informal meetings with the revaluation company.
Okay.
And in that email, could you also please confirm how many properties had their values reduced by the revaluation company as a result of those meetings?
I will.
If it's possible, there were 100 people who met and 10 of them had their properties reduced.
Yeah, I mean, I just hesitated because that could be a difficult report to pull out.
Okay. Well, why don't you see if you can figure out how long, what the period of time was, and then if you can, I'd like to know how many were reduced. It'd be helpful to know how many went and how many reduced, but at least how many reduced. I think if they were done, I think it quite, let me tell you where I'm going with it. I think it informs the public that there was a process to go, and a lot of people chose not to use it. And for those who did and who brought new information to the table, there were changes that were made. If
Right.
that was the case, I don't know if you did it, but
yeah, I don't know. There's definitely changes made.
so the point I'm making is then I think that it's important for the public to understand what that process was, that it was available to people, that it took place over a period of time. And, I think that going forward, the public will know there's an opportunity when there's a revow to engage in that process.
Right. I mean, it
Um,
should be easy. I just gotta see how it's flagged. They're supposed to be flagged properly. It'll be easy
I
if they
got it.
are.
Have you ever told a property owner that they could not appeal an assessment?
No,
Have you ever visited a property owner's property without the notice or without notice to them or their, so yeah, have you ever gone to a property without any notice?
yes.
And what type of properties did you go to without notice? Let me retract the question. Did you ever go to any residential properties without notice?
Yes,
When you went to a residential property without notice, did you step onto the property?
yes.
How far did you go onto the property on a residential property without notice?
If there was a house far enough to actually knock on the door to see if anybody's there.
And then if no one answered the, if someone answered the door, then what?
Depends on my purpose for being there.
What would be your purposes for showing up at someone's house, going to someone's house without notice?
So unless somebody actually comes in to make it clear, I mean, the way just about every assessor's office or reval that I've ever been to works is just about every property is visited without formal notice. One, we don't have the information to call. We don't have phone numbers for most people, emails, besides sending a letter. But you go on that and knock on the door to see somebody's there. Some of the reasons for going there would be a permit. If you saw something in the backyard that wasn't on the field card or something like that, maybe they had a shed back there, you're doing a review, you have their card, you say, hey, there's no shed on here, so I'm going to go inspect the property. It might be they have a dumpster in front of their house, no permits. You see a toilet out there or whatever, so you're going on to see what's going on with no permits. Different reasons for being there. If I'm there for a permit for a kitchen, I might leave my card for them to give me a call, but I'm not going to obviously go in the house. If it's because
obviously, yeah, so you're not going to go in the house. But let me just ask you this: do you has it been your process to walk around someone's property prior to getting notice?
So if I saw a shed or outbuilding in the backyard, I knock on the door, nobody answers. Yes, I will go out in the back and measure that property. This has been adjudicated in the courts before, and it's actually in 1255 state statute that the assessor has the right to go on anybody's property for a valid reason. I just can't go there because I want to, check out their backyard. I guess checking out the backyard is a valid reason for an assessor, but the assessor does have the state statute right to visit a property and walk on a property in the state of Connecticut without the owner being present or giving permission. So I kind of know where this is going. I mean, on the farmlands, if there's a five, I'm inspecting all the farmland and there's 5 barns that I can see. I'm going to drive back to that back barn to, see what it is, get measurements on it, see what's there or whatever. Obviously vacant land, there's nobody to knock on doors or notify anybody or whatever. So, I'll just walk back or drive back if there's a road to that property.
By the way, we talked about the BAA here in Enfield. What was your experience with the BAA in Bloomfield?
I actually tried to get them to be stricter. Their mentality was, well, if they don't have to pay that tax, I'm going to have to. So they didn't make enough changes from my experience, but we would meet before one time before all the hearings. I would go over every single property with them, told them my thoughts on it. And then they would go off, do the hearings, do their deliberations, and give me their decisions.
Did you have a, would you say amicable relationship with the BAs that you dealt with during your 4 years in Bloomfield?
Yes. Any other board that I've met with, any other town that I've worked with, any other board, I've had an amicable relationship with.
Did you ever have any issues or issues of concern that were raised about your interactions or involvement with the BAA in Bloomfield?
No,
Did you interact with the BAA in your prior position with the town of Wallingford?
I did.
And did you ever have any, were there ever any issues of concern with regard to your involvement with the BAA in Wallingford?
There was not.
How would you describe your relationship with the BAA in Wallingford?
Friendly, amicable, working relationship.
And would you and how would you describe your relationship with the BAA in Bloomfield?
The same.
So with regard to the BAA in Enfield, did you know Thomas Tyler prior to your appointment as the assessor?
I did not.
Did you know Donna Dubanowski prior to your appointment as the assessor?
I did not.
Did you know Lori Longy prior to your appointment as the assessor?
I did not.
Did you have any involvement with regard to the appointment of any BAA members in Enfield?
I did not.
At some point, there was, I think, an email from you to Ellen Zappo Suso, in which you mentioned that staff has concerns about Mr. Tyler. Do you recall that communication with the town manager?
Not specifically, but I'm sure there's probably something like that.
Okay. Do you recall why you may have communicated to her that the staff had concerns about Mr. Tyler's appointment?
It was very adversarial right from the start. My first communication with any member of the board, as the board, was when I popped in unannounced on their first special meeting. It was very hostile. I was also, prior to any of this, my staff, some of them been here for 20 years, didn't think that he was a good person to have on the board, just because they had too many connections, too many, again, Enfield needed to be cleaned up, that he was part of the good old boys club, and they didn't think he was a good appointment to give a fair and accurate hearing to the taxpayers.
And who specifically raised concerns about him to you?
Definitely both my assistants, Vicki Rose and Alyssa Hanvey. I also believe my clerk, Colleen Reedy, and pretty sure Jen Graham did too. So basically just about everybody here on the staff, besides the part-time person that was here that had only been here a few years. But all the other people have been here for a while. They basically know the players and the people in the town.
And what was the reaction you got with regard to that concern that was raised?
I don't recall what her response was.
Prior to the BAA doing its work in a new revaluation, or handling appeals from a new revaluation, do you have any thoughts about whether the BA should receive training, and and if so, what's been your experience with suggesting that a BA receive training or being involved with the training?
So in the past in Bloomfield and also here, my association, the CAAO, does offer a BAA workshop. And when that comes up, we offer it and put it out there to the board saying, hey, this is being offered. You know, do you want to attend?
And with regard to Enfield and the BA here and prior to the BA hearings that took place in 2022, did you offer the BA the opportunity to participate in that training session?
I believe we did. My recollection is that we did offer that. Confirm that with Vicky though. She would have been the one that would have sent the email to them. I'm almost positive we did. And nobody took us up on that.
Matt, we'll put it on our list. Matt will put it on our list of questions for Vicky. We could ask her. Aside from a separate training session conducted by the CAAO, did the town, for example, the town attorney or yourself or anyone else offer to provide a training session to the Enfield BA members prior to the hearings that took place in 2022?
Not that I'm aware of.
For the BA hearings that you did attend back in March of 2022, what were your observations?
They were handled very unprofessionally, in my opinion. I don't recall, and I asked Vicky about this. I don't recall anybody ever even being sworn in. I don't believe that the public hearing guidelines were actually followed. There was no flag. There was no Pledge of Allegiance. Even the agendas right from the start, there was no agendas. I mean, their whole, I'll get this on the record, I guess, their whole public recording rules and regulations actually aren't active or effective because nothing was ever put on the agenda. It was just brought up, already written up as a rules and procedures that Tom brought to the meeting. Everybody says we have these, do we accept them?
Let me stop you right there so I don't forget.
Yep.
Another homework assignment. You could assign some of the stuff to Vicky too, by the way.
Oh, believe me, I will.
So what I want to see is for every BA meeting they had, there would have had to have been a public notice that would have gotten posted. I want to see all those public notices.
I'll give you the notices. I'll give you the agendas. The agendas weren't actually agendas until we changed them this year. They didn't actually list what they were doing on them and stuff and everything. So they never actually.
I want to see the prior ones then as
Okay.
well. So I want to see what they in 2022 what they do. You know, what was the public notice, what was the agenda, and the meeting minutes. I want public notices, agendas, meeting minutes. Public notices, agendas, meeting minutes for all the meetings. And Matt, let me ask you this because I know you've gone through the BA records more than I have. Did you see that in the BA records that we got?
We may have some of them. I'm not sure we have all of them, but I can go through more carefully. And if we already have that, Todd, I'll let you know.
Well, I'd rather.
Online.
Yeah.
Oh, that's the other thing. That's right. We talked about that with Ellen, Mario. They should be.
Meeting and the agendas are online.
Yeah.
The only thing not online would be the notices. You know, the public notice of the newspaper.
All right. So then we'll. You sure the agendas are online?
There.
They should be.
So Matt, we'll pull the agendas and meeting minutes. I forgot about that. But Todd, you'll get us the notices, right?
I will.
All right.
And Matt, because he brought this up, did you see? I haven't had a chance to go through all the BAA documents. Tom states, the chairman states in his minutes and manifestos, his whatever, in the end, in the deliberations, that they all took individual notes and descriptions or whatever that they shared and stuff and everything. Are those actually included?
There were some handwritten notes included in what was provided. It was difficult for me to determine who wrote what and what some of the notes were. Sometimes I couldn't tell if they were provided by the property owners as part of their, appeal documentation, or whether they were done by the commission members.
Right. Well, it said all three of them took individual notes. So I'm wondering, I mean, FOI, according to Tom, all FOI stuff, those have to be provided. And I doubt they have been.
I'll double check. I'll look a little more closely, see if I can determine exactly what were the commission member or the board members' notes and what were the notes of the public, of the appellants, if any.
Okay.
So I interrupt you. You were telling me about your observations about the BAA, and I
Oh,
didn't
right,
want to forget that one thing that I wanted to ask you. But I didn't want to forget that. So
So I'm not sure that the public meeting rules were actually followed, but on all the individual hearings, the ones that I could actually hear anything, it was very unprofessional in my opinion. He obviously stated that, you know, the whole rules and regulations about recording. He did disparage, you know, myself in the office a lot, which I just don't think is good for the public. They were very secretive, talked very low, would push when they were meeting together. They would push paper between themselves, saying, you know, pointing at this. They wouldn't actually state anything. They would just kind of like push the paper along and point at something. They didn't actually state, well, this is, you know, hearing 121 for John Smith on this property. Some of them actually seemed to be pretty friendly. Some of them actually seemed to be coaching some of the things. Some of the questions were leading from Tom. I mean, I basically sat behind Tom for the most part. But there was certainly leading questions to the taxpayers, which, I mean, they can do what they want, but it just seemed like a very unprofessional way to hear the facts and what the person wanted and stuff. And I don't know if you knew, I mean, he actually screamed at me at one of those meetings. I mean, it wasn't one of the tax hearings, but one of their special meetings. I mean, he literally, I think he actually got up out of his chair and just screamed at me to shut the hell up.
So tell us about that. What happened there?
So one of the first meetings, when I was there, and it wasn't one of the ones being recorded because we weren't even thinking about that at the time. He started asking somebody else a question, and I just had knowledge on it and stuff and everything, so I started to speak up on it. And he just, I believe he rose up out of a chair. He might not have, but I mean, basically, I started to say something in a public hearing. I mean, I wasn't, you know, didn't have the floor or whatever. I probably should have, but he just basically just screamed at me, "Shut up! You shut the hell up! I don't want to hear anything more from you. I'm done with you." Paraphrasing, but it was something to that effect.
And what did you say?
I believe it was just, you know, some of my staff members. She was asking something about one of the staff, and I'm like, I believe it was because Vicky couldn't do the secretary hearing a portion of it and stuff. And they were asking, you know, if somebody else was, and I started to state up, well, we have a part-time girl that's done these hearings before, and that's when he basically just told me to shut the hell up. You can ask Steve Belinda that one. He was at that meeting.
Okay, so Steve Belinda was at the meeting. Okay, and how did you respond to his request for you to shut the hell up?
I shut the hell up.
Did Mr. Belinda make any have any comment when that was done?
He did not there. I mean, not in the meeting.
Did you have any discussion with Mr. Tyler after the meeting to confront him with regard to his interaction with you at that meeting?
I did not.
Aside from not confronting him in person, I guess, or on the phone, did you send him an email or in any way document what happened?
I did not.
You said that Mr. Tyler was asking leading questions. Could you please give a little bit better, more of an explanation as to what you're talking about?
Yeah, I mean, he was just basically asking questions about valuation. You know, so your property's next to a business. You think that affects the value type thing or something like that. Just trying to lead the person in the right direction of the right questions to ask or to get, you know, their point across, instead of just listening to what the appellant had. mean, one of his biggest statements that he always said just about every hearing that I heard was, which is fine, but so you're the owner of the property. Well, the courts have decided that, if you own the property, that you have the legal right that what the property is worth. Which I believe is accurate. I mean, I believe the courts have stated that, if you're the owner of a property, you can certainly state what you think the opinion is, your value is, but certainly doesn't make you an expert or actually know what the value is. It's strange on the timing because I'm reviewing all my motor vehicle, doing the grand list motor vehicles, and I'm looking at all the CSCs that were made because we always look at what they were valued at last year. And just to see that, like Jarmark had listed to the DMV that he bought a vehicle for $64,000 and the BAA reduced it down to $14,000.
I just want to make sure I have the right documents I want to ask you about. So can we take a 5-minute break? We'll resume at 2 o'clock. In the meantime, Todd, what's your hard stop?
320.
Yeah, whatever time you need. I don't care. We could do it earlier. I just
No,
just
320, 325 would be is where I got to get out of the office.
okay. All
I
right.
just have a doctor's appointment I have to be at for.
No worries.
Is there any
Yeah, just-
documents you want me to be looking for so I can review?
Yeah, that'd be helpful, actually. I was going to ask you about the legal opinion prepared by Jim Talberg
Okay.
regarding the recording of hearings.
Yeah.
That was dated March 30th, 2022, and then the
have
statement
that.
by Tom Tyler on April 4th, the significant document that he issued.
Okay.
And then there was a request for intervention by the
Yeah.
state of Connecticut. So
That
if you
might
want to
all
review,
be in one. Yeah, I think that's all in one packet.
well, he had a pack. All right. So anyways, so why don't you review that? Let's come back on at this is gonna take you a little time to do that. So let's get back on at 2:10.
Okay.
So 2:10, that gives us 15 minutes. I'm gonna review those as well, so we can kind of go through them quicker.
All right.
Thanks. Are back on. Todd, did you have a chance to review those documents?
I did.
Did you agree? You've had an opportunity to review the opinion letter issued by the town attorney dated March 30th, 2022.
Yes.
And what do you agree with his opinion?
I do.
And then did you have an opportunity to review the statement by Tom Tyler dated April 4th, 2022?
I have.
Do you agree with the position stated in Mr. Tyler's statement?
In the 3-page statement, no.
What statements did Mr. Tyler make which you do not agree with? That may be a loaded question.
When's my stop date?
If you could briefly address the.
Yeah. So just on the first one on 31022.
Briefly respond to that question, please.
31022 on the first page it states that I appeared unannounced at a public hearing to speak, and then I speak that I couldn't speak. This was actually brought up to the town mayor, and he had a discussion with Tom Tyler. Is you could have let him speak on the last thing on the notice or the agenda that was submitted was any other official business or any other business for the BAA. So I don't agree that I couldn't have spoke there. 31122. There was email written by my superior, Todd Helems. Vicky was the liaison. Everything went through Vicky. We had talked about what should be in the email. I don't know if that's considered me authoring it or not. But it wasn't any type of deceit or anything like that. I mean, it was all discussions were handled through Vicky. Just this might come up later on page 2 on the paragraph 33022. He states that he was never what is he actually saying here? And that they were never sourced. Facts upon this opinion was based, no facts were sourced, and the portrayal of my position was incomplete and misleading. I find that funny because of the Ray Romano thing, how he's stating that I didn't allow him to file an application, a BAA application. I mean, I was never contacted, or none of that was sourced or looked at besides Ray Romano's statement. And then on the last page, how he states that, many cases involve personal and financial information not subject to public disclosure. It's a public meeting. Everything that's said in a public meeting is up to public disclosure.
Was there anything else?
Those are the ones that I highlighted. I certainly don't feel that they were pressured or bullied into anything. Vicky never took minutes again. Didn't allow me to speak. That was true. I think that's the gist of it, short and sweet.
And did you have an opportunity to review a letter from the Enfield Board of Assessment Appeals dated April 6, 2022 to Martin Heff?
I did.
And did you have an opportunity to review Mr. Heff's response dated April 6?
I did.
In Mr. Heff's response, he states the BAA's authority is outlined in the general statutes and should be reviewed with the municipal attorney. Do you know if the BAA ever, after receiving that communication from Mr. Heff, ever reviewed with the town attorney as to what its authorities were?
To my knowledge, no, but you would have to check with the town attorney.
Mr. Heff's letter also states that FOI and the municipal attorney should be consulted regarding your amended rules regarding the recordings, broadcasting, and photographing of proceedings before the BAA, and that it's outside the purview of OPM. Do you know if the BAA ever reached out to the Freedom of Information Commission with regard to the amended rules, its amended rules regarding recording, broadcasting, and photographing of proceedings before the BAA?
I do not. But as stated before, I don't think their rules are actually legal. Have any standing?
Do you know whether the BAA, after receiving Mr. Heff's letter on April 6th, communicated with the town's attorney to inquire about the validity of their amended rules regarding the recording, broadcasting, and photographing of proceedings before the BAA?
I do not know.
With regard to the letter from the BAA to Martin Heff, are there, again, this is maybe a loaded question, so I'll ask you to keep your response as brief as possible. Are there specific statements made in that letter with regard to your involvement or the involvement of your, or the work of your office that you disagree with?
Yes. Surprise. Let me find out. Just had it. I was just reading it. That was in the packet of April 4th, wasn't it?
I don't know what packet it was in.
Come on, I just have it there. And got the date of the letter sent to OPM.
There, his letter to OPM was dated April 6, 2022.
I'm finding the response from OPM, but not his letter.
Did you find it?
I did not.
No? I don't think it's critical for you to respond. It's not that important. I can move on. It's fine. I can move on. Don't worry about it. So with regard to the meetings, the BAA conducted in 2022, it's my understanding that they conducted meetings in April. Is that correct?
Correct.
So my understanding was that the application deadline was March 20th of or 18th. The deadline was extended from February to March for BA applications in 2022. Is that correct?
It is.
And so therefore was the plan for the BA to conduct their hearings in April?
It was.
And did the BA also conduct hearings in May?
They had the deliberations in May.
And did the BAA receive approval from the state of Connecticut to conduct their meetings beyond April 30th?
They did.
And did the state provide authorization for the BAA to conduct their meetings through the end of May 2022?
They did.
Did the state of Connecticut authorize the BAA to, well, let me ask this. Did the BAA request for the state of Connecticut to allow it to conduct meetings after, with the exception of meetings that they would regularly conduct for appeals of motor vehicle or personal property in September and in the fall of 2022? Did the BAA make it a request to the state to request the ability to be able to conduct meetings in June, July, or August of 2022?
No.
Do you know if the BA conducted meetings after May 30th, 2022, in 2022?
They had meeting, yes, in May.
After the meetings in May.
Not to my knowledge.
So do you know if the BA conducted a meeting in June or July?
I'm sorry. Yeah, they do have some June meetings minutes. I'm sorry.
Did you ever, well, first of all, is it your opinion that the BA had the legal authority to be able to conduct meetings in June and July?
Not my specialty. I'm not sure.
Did you have any communications with the BA regarding any meetings that it scheduled in June or July of 2022?
I did not.
Did you speak with anyone? Let me take a step back. Do you know? Is it your understanding that the BAA retained their own legal counsel outside of the town attorney?
I know they had another attorney representing them, Attorney Bard. I don't know if they were contracted or what that professional relationship was.
Did you speak with anyone did you speak with any members of the board of the BAA regarding the BA's retention of Attorney Bard?
I did not.
Do you know if Vicky Rose had any communications with anyone at the BAA regarding the retention of Attorney Bard?
I do not.
Did the BAA submit to your office any bills for Ms. Bard's legal services on the BA's behalf?
No.
Prior to you becoming the assessor of the town, what was your understanding with regard to the retention of BAA records?
They've always been maintained by the assessor's office.
With regard to the 2022 appeals, were the records maintained by the assessor's office?
They were not.
Why?
The board refused to hand them over.
did you make a request for the board to provide those documents to those records to your office?
My office made the request and the town attorney's office, the yeah, Jim Talbert also made the request.
And what happened?
There was a letter received back to the town attorney stating that he was keeping them, that if they had any issues to contact the FOIC. And just to clarify, when you asked me about meetings in July, I'm thinking hearings. They didn't have any taxpayer hearings after May. So that was my confusion when you said meeting instead of hearing.
Understood. So you were aware of the meetings that took place in June or July?
I was informed when they set the agenda or the notice for the hearings.
Could you please, I guess is there online, are there meeting minutes for those meetings?
I believe so. There should be.
All right, so there's, Matt, let's just make sure we have agendas and meeting minutes for those summer meetings that took place. Todd, my understanding that the notices are not on the website. Could you please, when you get us the notices for the other BAA meetings, and get them for those as well?
So there are meetings minutes for June and July for the board online.
Are there agendas?
I'm just saying the minutes at the moment.
Let's see if you can find the agendas and notices for us, please.
Oh, the agendas are there as well. I'm sorry.
Okay, so then we just need the notices.
Yep.
It's our understanding that there were over 400 appeals, but that the vast majority of those appeals were taken by the same entities or families. Is that accurate?
I'd have to recount my numbers, but I believe that there was 100 and I want to say either 39 or 69 separate entities that filed an appeal. One taxpayer, Jarmick Farms, Connecticut Transportation, had about 25% of the appeals. 97, I think, was the number. They had almost 100 appeals out of the 400. I think there was 386 or 7 appeals. They had 97 appeals, I think. I believe it was either 139 or 169 separate different appeals.
Were there prominent property owners involved in these appeals?
Yes.
And who were they?
Jarmick Farms was one of them. There was a hotel. The Enfield Mall had several properties that they appealed. Connecticut Mulch. One of the larger names was they had several different appeals, but under different names. I'm gonna get the name wrong. It's not Anastasia. It's KR Leasing was one of their firms. What was one of their properties or business names? Antonacci. I'm sorry. Not necessarily listed under Antonacci, but I mean it's all sub companies or whatever under the Antonacci family, which interestingly enough is my predecessor's family-in-law. She's married into that family. Just to complicate things. And I did find that letter is right in front of me if you had any questions on it.
We could keep moving. So I want to ask you about some of these applicants. I want to ask you about Ms. Longy. So there's an appeal that was filed by David and Lori Longy for property at 78 Park Avenue. The appellant had a value of 15,000. It looks like the owner filed it. And the assessment was taken down to 0. Are you familiar with this application?
I am.
What are your thoughts about it?
My thoughts about it is that it could be criminal on their decision.
Why?
This is a parcel that was bought by the owner. They've subsequently been getting permits for a two-family house. I'd have to double check the dates, but I think they had a permit even before they went to the BAA. They're certainly in the process now of going to the board, the proper procedures to get a permit for a two-family house dwelling on it. Their reasoning of why the appellant thought it was worth 15,000, not 0, but 15,000 instead of, I think we had it at 40, was that it was unsellable because of a title issue. But the owner purchased the property for a set amount, so obviously it had value to her. My understanding is that there was a quitclaim deed filed even before the BAA hearing to settle the title issue. So I don't believe that there was any issues with the title. So the way it could certainly be perceived is that the board gave one of their own members a 0 tax on a property that's buildable.
When did Ms. Longy purchase the property?
I will have that. I don't have that right in front of me.
Well, I have a document in front of me. It looks like it was
16 maybe. I'm guessing.
looks like it was April of 2022.
Whatever. I mean, do you have the field card in front of you?
No, I just have the deed.
That might have been the quitclaim deed.
Yeah, there's a quitclaim deed I see here from,
That I think was that wasn't her purchase date. I think that was to clear up the title.
okay.
So that wasn't her original purchase. If you give me 2 seconds, I'm pulling up my system to actually check the date on it. 2016 sticks in my head, but I could be wrong. 28 Park Ave. So Lori and David Longy.
The field
November
card
28th.
shows, yeah, okay.
November 28th of 2016.
And then you made a reference to them cleaning up the title. What did that mean?
She stated that there was that they bought it from a foreclosure from the town, or they bought it from the town, but that there was a title discrepancy or issue, which her words that it made it unsellable and not worth anything. And I believe that, going through the process, they had the title cleaned up, and that the quitclaim was to take care of that.
Do you know how the quitclaim deed resolved whatever potential title issue there may have been?
I'm not sure exactly what the issue was. I'm sure it was just an ownership. I'm not privy to I didn't do any research on it.
Okay. And then it appears from some of the records we see here that in June of 2022, there was an application for a special permit to construct a two-family home.
I believe that's accurate. Yeah, I don't have all the documents in front of me. But
Matt, did we already ask the town manager to find the zoning records on this?
Yes, we did.
Okay. And she has not done so today, right?
I have not received anything, no.
I believe there was previous permits before that too, for building.
Did anybody from the BAA inquire with ask any information from you regarding this property?
Not from me, no.
Did anyone from the BAA ask for any information or documentation from your office?
Not that I'm aware of, no.
And with regard to this property, which currently has a value of 0 on the town's grand list for last year, what do you plan on doing with regard to this property on the 2022 grand list?
Bringing you back to its value that should be.
And what is that number?
It was originally assessed in 21 at 45,900 assessed.
And why do you believe you have the legal authority to change the value of that property as of the 2022 grand list?
I do.
Why?
Under 1255, I believe it is. The assessor has to certify under oath that all the values are true and accurate. Also under 1217A, I believe it is, or maybe it's 12111. There's a statute out there that says if there's a BAA decision that's the assessor doesn't agree with or can't sign on, that the following year, with the proper documentation, sending out to the homeowner, making documentation on the right records, the field card of why the decision's being made, that the value can be changed.
With regard to Connecticut General Statute 1255, does that statute provide the assessor with require the assessor to perform a watchtower type function?
That is the generic name of the statute, yeah, the watchtower rule.
And what is that rule?
Basically, to correct anything wrong that's out there. If you see a mistake, and this could fall under the PA 490 that we talked about earlier, anything that you see out there that isn't accurate or is a mistake that was made, or that it's just inaccurate, wasn't accounted for, was overassessed, whatever the reason, doesn't have to be under, it could be over. It is the duty of the assessor to make that correction when he signs the grand list. It's a pretty broad statute.
And is it fair to say that with regard to this property that we're discussing, that you feel compelled to change the value on the 2022 grand list in your acting in your watchtower role?
It is. I cannot certify under oath that I think the value of this property is 0.
And let me see here. Looks like there was an article in the Journal Inquirer in December 2nd, 2022 regarding, it says Park Avenue residents say 2-family house will lead to parking problems. Are you aware, did you have an opportunity to review this article?
I did not. I have only one article in my file, and that is the article about the Enfield to seek independent firms to investigate assessment discrepancies.
The article I'm looking at states that the Zoning Board of Appeals had approved variances from density requirements for Maiden Builders LLC, which is planning to buy the lot at 78 Park Avenue from the owners Lori and David Longy to build a 2-family home. And that the builders must now appear before the zoning commission for a special use permit, where their site review will be considered.
I believe that's been since passed. I think I recall something about hearing about that, but then they have actually gone to the zoning and checked with zoning, but I believe that was approved. And And that might have been approved before the hearing.
And the article makes reference to a potential sale of that property by the Longies to a builder. Are you aware of a potential sale of that property?
I am not.
If there is a sale of that property, do you think it's going to be for zero?
I don't call that a sale. I saw that a gift.
I want to ask you about another applicant, which was Mullen. Was Art Mullen.
Okay.
It looks like regarding a property on Mullen Road. Could you tell me about this property and the assessment?
The appellant came in and he appealed because he thought his assessment was too high. He stated that the upstairs was unfinished. If memory serves, that this is also the property where he had 2 outbuildings on the property, but the field card originally only had 1. Trying to make sure I don't commingle properties. But his biggest thing was that the upstairs was unfinished. And I informed him, fine, we just need to do a physical inspection of the property to confirm, and we can make the change for whatever's there. He refused refused, I believe, the reval company as well to go on his property. So it was a refusal. I do know that we reviewed this property and the reval company, the field reviewer, made the change of the upstairs from unfinished to finished in their review. And that was probably predicated because it was a refusal. And you usually value something on the higher side when somebody won't let you in their property. There's usually a reason for it. So if something's unfinished, you know, and it was a second floor is unfinished, you're gonna make it finished. But he did refuse me going out there, anybody from my office going out there for the longest time. We finally did, actually the finance department, John Wilcox, finally got him to agree to let his assistant, Greg Simmons, to go out to the property to inspect the upstairs, even though he's not affiliated with the office, doesn't know what to look for. But I basically told him what to do. I mean, if it's unfinished, it's unfinished. I mean, he came back, informed us it was unfinished. We did make the change for this year. Unfortunately, because of what the Board of Assessment Appeals set the value at, his value is set for that 5 years.
So essentially, the BAA gave him a significant reduction. Is that correct?
BAA did give him a reduction.
And even if you don't agree, you may not agree with their decision. Could there at least be a basis for their decision to reduce it?
There could be. I mean, I don't know what was provided at the BAA hearing. You know, if he showed them pictures or not. We weren't privy to that at the time. And like I said, I haven't had time to go through the BAA documents. If he provided documents or evidence showing the value was different.
Is it fair to say that that with regard to this property, your decision is going to be to respect the decision of the BAA, and if there's no further change to the property during the revaluation cycle, that the value set by the BAA will remain in place until the next townwide revaluation?
It will. I'm not going to go. I mean, I don't always agree with their decisions on value based. I mean, if somebody values what we just talked about, a buildable property at 0, obviously that's a bigger fruit than somebody, you know, lowering something 20, 30, 40 grand. I'm not going to go back and put my opinions or thoughts and change something on something like that that the board did. So it will stay the same for 5 years.
So I see a note here from John Wilcox to Ellen in July of 2022, and it says, after the properties owned by Mr. Mullen were revaled, a notice of change was sent to each property owner, and they had the opportunity to meet with Vision to discuss the results. And then he attached notes from the meeting with Vision. He stated, it seems like this could have been resolved at that time. What does that mean?
Well, they have the same criteria that I do, is that any material change like that, square footage, finished basement, unfinished area, whatever it might be, a simple visit of the property to confirm, you can make that change.
So is it fair to say that, Mr. Wilcox's position was that this issue should have been resolved back in December of 21, when the property owner met with Vision?
I don't want to say should have, it could have been if it was allowed an inspection. It
So
would have been if there was an inspection allowed.
is there, in hindsight, is there something you could have done differently to have resolved the issue, the issues pertaining to the assessment of the Mullen property?
I could have just given the taxpayer what he wanted, but short of that, without visual evidence, there's nothing I could have done without him allowing me on the property.
And do you believe you made, did you make attempts to try to view the property?
I made attempts. I mean, I talked to Mr. Mullen multiple times stating, just let us on the property and we can fix it. And it was always, rebuffed.
Do you believe
I never
that
went, knocked on his door, no.
did you make multiple attempts to try to view the property so you could resolve the issue?
We visited the property, well, for the reval, we were there November 6th in 2020 and then October 28th. So we were there twice for the revaluation. There was another attempt when he did the BAA hearing in December. He's been in my office multiple times, and every single time it's been stated, just let us on the property and we can fix it. So there's been multiple attempts to be able to fix this property.
So with regard to Mr. Mullen, is it your position that you identified the issue, which was that you needed to do an inspection, you made numerous requests to do it, and he refused to allow you to do so, and that had he let you would have resolved the issue? Is that, I mean, to put words in your mouth, but based on your
No, that's accurate.
responses, is that accurate? Okay. So with regard to Mr. Mullen, is your position that there's nothing else you could have done to have helped him if he wasn't going to allow you to view the property?
Correct. Yeah, I mean, there's nothing under my purview that I could have, to be fair and equal to everybody else, there's nothing else I could have done.
Did you ever offer for him to give you pictures and video in lieu of you physically inspecting it?
We did. I mean, when it was here in the office, I mean, I said, one of my staff can go, I don't have to go. You can show us pictures. I mean, people build things out all the time, without permits and stuff and everything. So, we have no proof that especially a second floor, how long does a second floor usually go unfinished in a house? It's not the norm for certain.
No, I understand that. I'm just asking, aside from you going there, you offered to go there, he declined, correct?
Correct.
You offered to have another staff member go and he declined, correct?
Correct.
And did you just respond that you offered for him to either show you pictures or video in lieu of somebody physically going inside?
We did offer if he showed us pictures.
And what was his response to that?
He declined that as well.
And then ultimately he allowed someone from the finance department to go in, and you coordinated with that person to get the information back from them?
Correct.
Okay. And once you received the information based on that person confirming what was physically there, what did you do?
Made the corrections in the system.
And as a result of the corrections, did the value go down?
The value did not go hard-coded value set by the BAA.
Oh,
So the
'cause if
value
that-
doesn't change, but all the information in there is correct, the sketch, the square footage, that was changed, but the value didn't change because of the board's decision.
But going forward, that area will not be valued as improved as it previously was valued because the field card has been corrected. Is that correct?
Correct. Correct.
I know you referenced earlier that the Jarmock family had approximately 100 appeals. My understanding is the appeals included appeals of properties that had farms, had solar, and there were also motor vehicle appeals. Could you tell me about the Jarmock farm appeals?
A lot of the appeals were on the barns, the value of the barns. There was a couple of appeals of he bought a piece of property from another farmer. Filed a PA 490 application. It was missing a couple of key components required by state statute components. We sent out a letter to him asking to, supply those to fill those in. He responded by filling out one of them, but not both. So the appeal was basically never accepted, or not the appeal, but the PA application was never accepted because it wasn't complete. He appealed that to be able to get the PA 490 exemption to the board, which they granted. Some of the other ones were just on PA 490 status. He's got a commercial business out there, a trucking business. That's not allowed by zoning. I think zoning's actually kicked them out. I mean, there's been a big issue with that. We took part of that property because there was a commercial business on there and valued it as a commercial property instead of the farm. The board threw that out, gave it all back, gave all the PA 490 back to him. He had some issues about the tillable A or B or whatever, making those changes. You went sideways there.
Sorry about that. My camera fell.
He was one of the ones that, he just cleared out some property and stuff and everything, and the two on either side was tillable B. Doing this from memory, but he applied for this application for tillable C. I'm like, well, both on the other ends are tillable B. How is this one any different? So, I mean, I did change that. Any changes I made, the board reversed.
And the solar?
The solar was so they're leasing property to a solar company. There's a tax agreement, not an assessment agreement, but a tax agreement with the town. Tax agreements have nothing to do with assessment value, has nothing to do with this office, with the assessor's office. The property itself is not exempt. It's basically a business property. I mean, it's a leased business property. Jarmock is making money off the lease of the land. It has not been exempt in the past, and Jarmock filed for the exemption, and the board granted the property as exempt. Even the barns and the area of the property and stuff and everything that are obviously still part of the farm. So they actually exempted the outbuildings
And the motor vehicle?
The motor vehicle, he basically came on, from what I saw. I mean, I haven't looked through the records, but what I could see from sitting behind him, he came in with his own spreadsheet of what everything was worth. There was a couple of items on there, note that, I mean, I did supply to the Board of Assessment Appeals. They didn't ask for it, but I supplied it anyways. There was one vehicle, it's a tractor trailer. He had two of the exact same vehicles, same make, model, year. He had just sold one of them for $100,000. We provided that bill of sale to the board, showing that exact same vehicle. He just sold it for $100,000. I believe they reduced it to 20-something thousand. I'd have to look up the number, but they reduced it something ridiculous. My belief is that they just took whatever he had on his spreadsheet and used. I just looked at valuing the 2022 grand list for motor vehicles, a 2016 pickup. that he had bought for $64,000. The board reduced it down to $14,000. A lot of his equipment or vehicles, they just reduced down to 500. I mean, whatever he wanted to come in there. He's got a brand new 2021 F-350 King Cab, crew cab, that I think they valued at $20,000. It's an $80,000 vehicle. It's brand new. It was brand new at that point in time. We're a year later now, but it's easily an $80,000 vehicle. They just reduced it down to $20,000. And I don't believe they had any evidence, documentation or anything like that besides his spreadsheet of what anything was worth.
Could you tell me about Easy Pickens Farm?
So Easy Picking Farms, they have a farm, orchard picking, very popular in town, but they also have 2 separate wooded properties along the road that abut it, that were put under PA 490. I don't believe they ever should have been. It's just 2 pieces of woods, doesn't have anything to do with the farm. I originally took him off PA 490 because there was no farm unit involved. They did appeal to the town, not the BAA, but they might have appealed to the BAA, but I think they removed themselves because we settled it beforehand. So in reviewing, and these aren't the only ones, but in reviewing anything that was granted the way the PA 490 works, this is where the watchtower rule, in my opinion, fails. It doesn't cover this. If something was granted in the past under PA 490, you cannot remove it unless there's a sale or a transfer or a change of use. Doesn't matter if it wasn't ever supposed to be in there, whatever the case may be. After reviewing and talking with the appellants, we had meetings in the town manager's office with the appellant. We reversed that and gave them back their PA 490 land exemption on those properties.
Essentially, did you make the decision to grant them back their exemption on these properties?
I did.
And so what made you change your mind, or it shouldn't be say your mind, but what was the basis for your change in your decision?
Well, after reviewing the facts and the statutes and talking to some of my colleagues, you even if it's wrong, and then it should have never been granted PA 490 status, you can't change it unless 2 things occur. There was a sale or transfer, which did not happen on this property, or there was a change of use, and there has been no change of use on this property. It's always been woods. It's stayed that way. Even though he stated he was saving the property for his grandkids, he said this in a meeting with the town manager. He doesn't ever intend using it for the farm. He's just, if he wants to give it to his kids to build a house down the road, his grandkids down the road, is the only reason why he's holding onto the property. But those 2 changes didn't happen. After reviewing the facts and talking with the owner, made the decision for this one, and that also reflected back on certain other properties that I made changes to that I had previously removed, but because nothing had changed on the property, I gave it back.
So is it fair to say that on a certain number of properties in which there were PA 490 exemptions, which you took away, you, upon further review, decided that that was not the right decision because on the basis that there was not a triggering event as required under the statute to make a change, and therefore you gave those exemptions back?
Correct. That's fair to say.
Is it fair to say in hindsight's always 2020, that you would not have taken away the exemptions on those properties because there was not even if you believe that they didn't qualify, but because you wouldn't have done so because there was not a triggering event?
Correct. And I won't, going forward, I won't make that mistake again.
All right. So you made a mistake in your application. Is it fair to say you made a mistake in your application of the PA 490 law with regard to this very specific subset of properties, and that with regard to this very specific subset of properties, or the application, I shouldn't say a subset of properties, with regard to the very specific application of a very subset of the law, going forward, you will not remove an exemption unless there's a triggering event as required under the statute?
Correct. I mean, an error in judgment, it was discovered and I reversed it.
When you say it was an error in judgment or error in the application, in your interpretation of the law?
Yeah, it's not really a judgment. I mean, it's a state statute, so I guess that's not a judgment call.
I think you'd want to clarify, right? I mean, was it that
Right.
you misapplied a very specific, a very small part of the statute, essentially?
Yes.
Now, when these folks, every so many years, they've got to file a quadrennial application. Is that correct?
Every 4 years.
So when they file their next quadrennial, would you, for these, for a property, like, let's say Easy Picket Farm, when they file their next quadrennial, do you have to then make a determination as to whether it qualifies, or does it automatically qualify unless there's a triggering event?
That one you have, I mean, pick somebody else besides Easy Pickens because they're not a quadrennial applicant, but yes, I mean, every 4 years, even in between, if it doesn't fall, if they fall out, you can remove it. The requirement is for them to apply every 4 years. And then, yes, it's not the same as the BAA 490. You make a decision each and every time.
I'm sorry, I'm conflating things. The quadrennials are for nonprofits. That's different than the PA 490 applications, correct?
BAA 490 is a special use value. Quadrennials are the exemptions for the churches and the.
Yeah, so my question was incorrect. Sorry about that. I'm starting to get myself confused. So the bottom line is, with regard to the PA 490, they don't have to reapply.
They do
Unless
not, unless there's a change of use.
So
Or
they
sale.
So they continue to use for 20 years. If they're exempt, they could continue the current use for as many years without having to reapply. Is that correct?
As long as there's no sale, transfer, or change of use. And it's not exempt. I mean, that can get the confusing part.
I understand. Well, it's exempt to the extent that it's a lower value and
Right.
I get it. Okay. So talking about some nonprofits, tell me about the Moose Club.
So the Moose Club has been getting the exemption, I think, for about the last 10 years. They didn't always receive it. For whatever reason, at one point they applied and the assessor at the time granted it to them. They're a social club. Social clubs under general practice are just not exempt. We had several meetings at the town manager's office with them. They supplied all their documents. We reviewed it. Town attorney looked at it. I mean, the Moose had a high, had a lot of eyes looking out. But under the statute, they're not exempt. So I removed the exemption from it. They applied to the BAA and the BAA granted it back to them.
So the BAA granted the exemption for Moose Lodge. Is that correct?
Yes,
And what are you going to do with the Moose Lodge on the 22 grand list?
remove that exemption.
Why?
Same reason stated for the Lori Parkey, Lori Longkey property. I mean,
So
it doesn't qualify.
So you'll be changing the value.
The value is
back
going
to
to stay
what
the
it was
same.
before,
The exemption is going to be removed.
based on under your authority under 1255. Is that correct?
Correct.
Tell me about the Mount Carmel Society.
Mark Comrell was kind of a gray area. So they do a lot for the town. This is one of the ones where it's kind of left up to these. Well, it's always left up to the assessor's discretion. The assessor is the one that decides the exemption. I was conflicted on this one, but they do a lot of good things. They allow the town to dump the snow. They allow them to use the fields for sporting events. Council meetings. There's been different meetings. They've been able to use the building, so This one's a little bit more gray than the Moose Club, even though it is a social club, it's a little bit more gray because of the benefit they do to the town. So this one, even though originally I was going to remove it before I signed the grand list, after all the hearings and meetings that we had with the interested parties, I did allow the exemption to go forward, except for the vacant piece of property that's next to the highway. Vacant land is not exempt, even if it's owned by a church, unless it's being used for that specific purpose. This has been well established in the Supreme Court. You know, there's a Waterbury case about the whole Holy Cross and stuff and everything. You know, vacant piece of property that church made a pilgrimage out once a year under the cross, had, you know, a little get together, whatever. The courts decided that no, that does not constitute being used under your purpose. Vacant land is not exempt. So I did remove that exemption and put the value on you know, a normal vacant piece of property. The Mount Carmel went to the board and they wanted a value of, I believe, $10,000 because that's what they bought it from the state. But they didn't buy the full bundle. One, it was 20, 30, 40 years ago when they bought it, so that value is old. But they also didn't buy the full bundle of rights. They have no right to sell that property, build on that property. They only have the right to use that property. So that's the only rights they actually bought from the state. So that $10,000 does not equate to a fair market value for that piece of property. But they went to the board, BAA, and the BAA granted the exemption as zero.
Todd, with regard to the Mount Carmel Society, what would you say were the specific reasons which resulted in you changing your decision to go from to take away the exemption than to grant it back?
I would say the biggest ones were the benefit to the town that they were supplying to basically municipality, government, however you want to word it. They were providing a big benefit to the town of the use of the property, and, you know, different instances where they stepped up to the town for various reasons.
Do you so you mentioned examples of what they've done in support of the town, but did the manner in which they were using that property, do you believe it qualified for exemption under Connecticut General Statute 12-81?
So I believe that's a gray area. It could have went either way. There's 3 legs to stand on to be qualified. One of them is relieving the burden of the state or municipal or government. So, I mean, I think they definitely had an overwhelming case on that leg of it. And to be honest, everything else that was happening, all the other pressures that was going on, did I bend a little bit on one way or the other? Sure. But I do believe it's in a gray area that probably could have went either way.
In hindsight on that one, do you think that you could have made a better effort to work with the organization to understand all of their uses of the property, which may have qualified them for the exemption?
This is going to fall under the time frame and the resources that you have. I mean, could we have reached out and had more meetings if we had more time? I mean, this was the perfect storm. It was the quadrennial year. It was the reval year. New assessor coming in. You know, it was the perfect storm for trying to get everything done in a short period of time. Quadrennials are due by November 1st. We have to sign the grand list, 3 months, as well as doing all the other normal assessor work with grand lists of motor vehicles and personal property. If I had more time, sure, we could have reached out more. We do send out, I mean, they are required to fill out the quadrennial with all the documents they think, we need for them to qualify, stuff that we should look at. So some of it falls on the taxpayer itself to make sure that we have all the information available that they want us to know. But more time, more resources, sure, I could have reached out to them and had a longer time to review everything.
Aside from resources, putting resources aside, do you think that you could have, in hindsight, with the same resources, have taken a different approach with them and tried to maybe be more user friendly, to try to assist them with qualifying for the exemption?
Well, my first blush being new to the town, reviewing the only information I had was their quadrennial, which was late in getting. They didn't even know they were supposed to file one. So we got the quadrennial, I reviewed it. My first blush was that it was a social club, just like the Moose. It's not exempt. So I didn't feel the need to reach out to get any more information. My assistant lives right next door to the Mount Carmel. She doesn't think they're exempt. My tax collector assistant, she's been in town, 20, 30 years. She doesn't think they're exempt. So, I was getting information from not just the quadrennial, but other people familiar with the organization. So I didn't think I needed any more information from them. If I thought it was more of a gray area, yeah, I probably could have reached out and said, hey, what else you got? But for everything that I had and the pressures, I don't want to say the pressures, but the time constraints, I know you said to keep that out of it, but at the time I did not feel the need to reach out to see what else they had. I felt I had all the information needed to.
No, but I'm asking now in hindsight, do you think that you should have reached out and made that effort, regardless of, irrespective of what your time constraints were, that it would have been the right thing to do in hindsight?
In hindsight, politically, it was definitely the right thing to do. They're very prominent in the town. I just have a hard time with Mount Carmel because I'm still going back and forth whether they even are exempt. So I have.
But you ultimately made the decision to exempt them.
I did.
And so since you ultimately made the decision to exempt them, in hindsight's always 20/20. And I'm not trying to tell you how to test what responses to give me. So
yeah, in hindsight, I certainly could have done a little bit more to find out, who they actually were and what they were doing.
I know I want to respect the fact that you've got to head out to an appointment. So do you want to do 5 more minutes, or do you want to end it now?
We can do 5 more.
So I just want the last subject I just want to talk to you about for right now is outreach. So do you think that there were some applications and there were a number of applications in which you took away an exemption and then at some point gave it back? Is that correct?
On the PA 490, yeah, it was.
But not just the PA 490. There was this nonprofit. Were there any other nonprofits?
Not that I can recall off the top of my head.
Okay.
I'd have to review the list, but I can't think of anything that I gave back.
Other than Mount Carmel, is that correct?
Correct. And one could argue it wasn't really giving back. It was never taken away. It's not taken away until the grand list is on.
No, you absolutely didn't give it back. I should not have used that phrase. Change your mind. So I guess the question I'm going to ask you is, again, in hindsight, you're new to the town. You had a different approach. Where you handled. Is it fair to say you handled the quadrennials differently than your predecessor?
Yes.
And is it fair to say that you conducted a review of the PA 490 properties in a manner that was different than your predecessor had handled it?
Most definitely.
So because you handled the quadrennials differently, because you handled the PA 490s differently, do you think with regard to the quadrennials and the PA 490s, you could have done a better job in administering your office or working with other town officials to get better PR out to folks about the requirement for quadrennials, the requirement for what the requirements are for PA 490? Do you think from a PR, the PR from a PR perspective that you could have done, a communications perspective, you could have done more? Or better?
Certainly the PR, the press, the notices in paper, notices on the town websites. Certainly there could have been more done as far as the public notices and stuff and everything. And just a side note, just to make it interesting, I did talk to my predecessor, Della Fremont, about Mount Carmel and the Moose. And surprisingly, she doesn't think either one of them should be exempt either, that either one of them qualifies. Even though she allowed it, she doesn't think they should be, she doesn't think they qualify.
Okay. But let's just go back to this last issue for today. What do you, in hindsight, what are things that you think you could have done differently? And but more importantly, what are things that you're gonna, let's put it this way. Going forward, what are changes you're gonna make in your approach with regard to PA 490 and properties and the nonprofits that have to file quadrennials?
Well, going forward, hopefully everything's somewhat cleaned up and it's not going to be this big of an issue, but going forward, I'll certainly reach out more to take advantage of other departments. If I can get the town manager's office, we now have a social media director, I believe, or a public relations person, whatever the title might be. We just utilized her to put out a release of tax payments due by the end of February or by the beginning of February. So that's another resource that we can tap into. You know, maybe something at the senior center for some of the things. Maybe try and reach out to different departments that you know, so it's not all on this department because of the resources. But to try to spread it out to the departments that are relevant for whatever issue it might be. You know, we have an agricultural committee in town that was never involved in anything. We certainly could have reached out to them to see if they could have reached out to the farmers about this type of stuff. Some of the issues, you know, some of the things I've thought about, you know, going forward that might help better get the word out there about what's happening. Because the problem with this office is, and you're probably aware of this, is that nobody knows what we do. You know, and when somebody doesn't know what's happening, you know, they get nervous and upset when something happens that they weren't aware of. So making the taxpayer more aware of what this office actually does, what the rules and requirements are, is definitely going to help in the PR issues.
Okay. Going forward, do you think you'd make any changes as far as helping folks with the, you know, applying for doing their quadrennials or with regard to PA 490 properties?
Well, I mean, we do send out the applications. I mean, we can't stand behind somebody to get them to fill them out. I mean, we certainly, just like with personal property, we send those out. You know, people don't return them. Short of putting out notices, you know, in the newspaper or whatever, you know, this is due then, you know, if you're this type of person, then you got to get this application in by this deadline. I mean, you can always do town hall meetings. You could have the council announce things. You know, that might be something that the town manager can get involved with, having some of the council members saying, hey, you know, PA 490 is coming up, or if you have a farm, you have to do this. If you just sold your property, or, you know, this is the year for quadrennials. Next one's going to be 2025. You know, make sure you get them in by November 1st. So at the town council meetings, it certainly could be noticed. You know, there's the town website and the town boards and stuff and everything that you can put notices out on. Basically, it's just getting the word out there for the people to know, so they basically can't say, well, I mean, one of the common things is, well, we didn't know we were supposed to do that. Even though it's incumbent about the taxpayer, just like you're supposed to know you have to pay your taxes.
Okay. So I think it's a good time to stop. I only have about another hour, maybe hour and a half, and at this time. So what?
Originally, you told me 3 hours.
What did I say, 3? Man, I do a little more than that. I think I said my best guess. All right. So I probably have another hour. As far as reschedule, just scheduling that, and then I may have some follow-up later. We may do one more follow-up interview with you, but let me see here and take this off. I'm gonna stop the recording.